Well, since everyone is seated and so quiet, I'm going to go ahead and get started. So good morning again, everyone. Welcome to day 2 of the symposium. So yesterday we explored the structural foundations of the 2026 World Cup in North America. Our discussions examined regional legal frameworks, the role of the USMCA, and the ways trade, labor, and mobility intersect with mega sporting events. What became clear from those discussions is that the World Cup is not simply a tournament to be organized. It is a complex system of governance involving public institutions, private actors, and international regulatory bodies. So today we turn to more directly to the normative and operational questions that arise from that system. Our sessions will address issues such as human rights, due diligence, and ethical accountability in global sport. Dispute resolution and the intersection between domestic law and lex sportiva, the growing influence of technology, media, and cybersecurity in modern sporting events, and the infrastructure and procurement decisions that shape the long-term legacy of the World Cup. So together, these discussions will help illuminate how a mega event like the World Cup operates not just on the field, but within a network of legal and institutional frameworks. With that, we will begin our first session of the day, which focuses on human rights, ethics, and dispute resolution. So I am pleased to welcome again our moderator, Professor Matt Mitten, Executive Director of the National Sports Law Institute at Marquette University Law School. Oh, I'll go first. Yeah.
All right, well, hello again, everyone. So in addition to being a sports law professor and scholar, I've also been a Court of Arbitration for Sport arbitrator since 2007. And, this session on, human rights, ethics, and dispute resolution, I think is particularly important today. And, I got appointed to the CAS back in 2007. And, one of the things it's hard, you always have to take off your law professor hat because as an arbitrator, you are an adjudicator, not a legislator. And you interpret and apply the law, which is basically the governing body rules, which you don't have a role in enacting, which you shouldn't, as well as applicable laws. And sometimes that's a big issue, is what laws actually apply. And then you reach a decision, and sometimes you don't like the result. But that's the role of an arbitrator. You're not a legislator, not a policymaker. So when Karen had said, well, you get 5 minutes or so as an intro, I remembered that back in 2014, I did an article on the Court of Arbitration for Sport and its global jurisprudence, international legal pluralism in a world without legal boundaries, which was published in the Ohio State Journal on Dispute Resolution. And as I read that and then Frea's article, I said, wow, it's going to be, here's where at least I saw things after 7 years on the CAS, 10 years ago, and look where we're at today. Well, actually 12 years ago. So if you can indulge me for a minute, I would read you some, just very briefly from the article. So what I had said, it started out with, because Olympic and international sports competitions occur worldwide and are based on consensual relationships among global entities and athletes throughout the world, universally accepted rules and a unitary dispute resolution system are necessary for their effective internal governance and external regulation. You know, we're still there today, but structurally it's going to change a little bit. The Lausanne, Switzerland-based CAS arbitration system. What's important about that is, as many of you know, regardless of where an arbitration is held, the seat is always considered Lausanne, Switzerland. So Swiss procedural law applies, and then CAS awards are reviewable by the Swiss Federal Tribunal, Switzerland's highest court. So I've been involved on, I think, 25 plus CAS panels. I've only ever had one case in Switzerland. My first one was in Denver, Colorado. I've had one in Rio, Brazil, Sochi, Russia, Tokyo, and Paris, most recently for the Olympic Games. So this demonstrates, you know, how a civil and common law legal system can function effectively together with an international tribunal to resolve a wide variety of complex, time-sensitive disputes between parties of different nationalities. So the whole objective is to produce a globally respected adjudication of Olympic and international sports disputes. And, you know, it's kind of misnamed because, of course, the CAS is not a court. It is a private arbitral tribunal, and it's not established by the agreement of sovereign countries. It's a form of international pluralism that's developing into and functioning as a de facto common law legal system. It's kind of interesting. Switzerland has a common law legal system, but it's very much common law because arbitrators rely upon prior CAS awards, and those are certainly cited by the parties in the case. And then Professor Jim Nafziger, who was on the planning committee, unfortunately couldn't make it. He had accurately observed that the CAS has established, quote, the gold standard in resolving sports-related disputes by ensuring fairness in terms of even-handedness, impartiality, acting in good faith, and coherence. Not everyone would agree with that, but Jim's, you know, the top international and sports law professor, so I do, and based on my experience. So what we'll see arises is the Swiss Federal Tribunal. It can review the substantive merits of awards, and it can vacate them. It's done so in a very limited number of cases if they violate Swiss public policy law. But the Swiss Federal Tribunal does not consider European Union law or European Union public policy as part of its review. So that creates the problem here. So how did I end up with the conclusion? So I put, you know, legitimate public policy questions may be raised about whether such a limited scope of judicial review of CAS arbitration awards effectively protects athletes' rights. That's the key thing, because it's pretty much compulsory arbitration. If you want to participate in the Olympic Games or, you know, any of the world competitions, you have to agree to CAS arbitration as resolving the merits of disputes. So basically what athletes have to do is at least initially forego their right to litigation, at least initially, unless they want to challenge the rules themselves. Then they can go and challenge them in a national court. So what I had suggested that, you know, despite all of these problems, and no public legal system is free of any of them, that on balance, a consistent body of CAS jurisprudence that is uniformly applied to the world's Olympic athletes with limited disruption by national courts probably is better than the risk of a potentially conflicting body of international sports law unduly influenced by nationalistic interests throughout the broader judicial review. So what our two presenters are going to do is consider the substantive human rights laws that apply to international sports competitions. Karen's going to talk about specifically the 2026 World Court and their source, as well as the procedural requirements and substantive constraints of European Union and European human rights laws in CAS arbitration, and the role of European national courts other than Switzerland in judicially reviewing CAS awards for compliance with European public policy. That's largely what Frea is going to do. So as a CAS arbitrator, their views are particularly of particular interest to me, and I want to compliment Frea on her paper. I thought it was really excellent. I'm going to send it to Michael Leonard, the new president of CAS, and have him read it, because it's a very good overview, particularly for those of us from the US who aren't as familiar with European Union law, and illustrates the importance of this conference. So, Karen, I think you're coming up to present first.
Yes, me again. Me. Slides. Okay, probably. Ah, thanks, that's that. Yeah. Okay. Okay, well, thank you, Matt. I actually, for now about, 12 years? About 12 years now, I've been doing a court of arbitration for sport CAS case summaries, series with the International Encyclopedia of Laws. And so you mentioned the CAS, and yeah, so that has been a very interesting project. So it's nice to know all of the experience that you've had actually sitting on the CAS. So yeah, very interesting. So first of all, before I get started into the presentation, I do want to say a couple of things. One, this will be a bit of a carry-on from the conversation that was sort of started with Lynn Carrillo, that I raised around human rights and actually, having the commitments to human rights that are part of the due diligence process, part of the bidding process, due diligence. So this is a bit of a carry-on from that. The other thing I wanted to mention ahead of time is that this is just the beginnings of research, okay? Unfortunately, I did not complete the research. I didn't complete the paper. So I had a few other things I was dealing with, but so just setting expectations as well. And then finally, the other note that I will kind of mention is that I am going to rely quite a bit on my notes, so my apologies. I don't typically like to handle presentations this way, but I'm dealing with a few issues, so I needed to feel secure in what I'm presenting. So, with all of the disclaimers out of the way, my presentation is titled From Symbolic Compliance to Enforceable Oversight: Human Rights Due Diligence and the 2026 FIFA World Cup. So over the past decade, the governance of global sport has undergone an important shift. International sports organizations now routinely recognize that they have human rights responsibilities. The question is no longer whether organizations like FIFA have human rights obligations. They do. The real question is whether the institutions that govern global sport are capable of enforcing those commitments. So using the 2026 World Cup as a case study, and since we're still leading up to the 2026 World Cup, obviously I can't complete the research because we're still in this process. But using the current World Cup as a case study, my research examines whether the growing adoption of human rights due diligence frameworks grounded in the United Nations guiding principles on business and human rights, represents meaningful regulatory progress or whether deeper structural reforms are still necessary. The guiding principles endorsed by the United Nations Human Rights Council in 2011 established a now widely recognized protect, respect, and remedy framework for corporate human rights governance. And remember that reference to corporate. They have since become the dominant global framework for understanding the human rights responsibilities of private actors. So why this matters? Well, mega sporting events operate at the intersection of global commerce, public governance, and international human rights law. Events like the World Cup generate billions in infrastructure investment, large-scale urban redevelopment, and intense global media attention. Host governments often emphasize the benefits: tourism, job creation, infrastructure development, international visibility. Yet research over the past 2 decades documented a recurring set of human rights risks associated with mega events. Now, these include things like displacement linked to urban redevelopment, labor exploitation in construction and service sectors, restrictions on protest and freedom of expression, expanded surveillance and policing practices. And many of these rights are protected under core international legal instruments such as the International Covenant on Civil and Political Rights. Now, that was a landmark treaty that was adopted in 1966 and put in force in 76 for fundamental rights, life, freedom of speech, religion, assembly, fair trial, and then also the International Covenant on Economic, Social, and Cultural Rights, the ICSCR, adopted also in 1966, and requires states to progressively realize the right to work, health, education, adequate standard of living, etc. So the problem across multiple World Cup cycles, the pattern is consistent. Deaths go unexplained, compensation remains incomplete, and grievance outcomes remain opaque. The problem is not simply compliance. It is the absence of enforceable oversight. So the question is, can governance structures prevent these harms? And just a side note, I started to include a video of some of the actual workers in previous World Cups. But this is a problem that despite decades of documented abuses linked to mega sporting events, only a small number of victims have ever reached any type of formal remedy. The point is reinforced in work by John Ruggie, Human Rights Watch, and Amnesty International. So the cases of human rights abuses, the issues that arise around World Cups has been very clearly documented. And I will touch base on a few of those a little bit later as they relate to certain of the past World Cups. So to answer this question, can governance structures prevent these harms? We must first understand the institution or the institutional role of FIFA. So, but formally, FIFA is a private association organized under Swiss law. But in practice, it exercises significant transnational regulatory authority. Through tournament regulations, host agreements, and government guarantees, FIFA influences national legislation, municipal policy decisions, and infrastructure development. Host governments often adopt special legal frameworks in order to meet FIFA's requirements. Legal scholars such as Antoine Duval and Roger Pilkey Jr. have described this phenomenon as transnational private regulation, where private sports federations exercise rulemaking authority with significant public consequences. So in this sense, international sports federations increasingly function as private global regulators. So the human rights shift. So this governance structure came under increasing scrutiny during the 2010s. In response, FIFA, and as you can imagine, during the 2010s with the World Cups, all of these issues coming out, right in the midst of, the United Nations, coming up with the guidelines on human rights as it related to business. Well, right in the midst of all of this, with the UN Guiding Principles coming out in 2011, the World Cups, all of the issues around human rights. Then in 2017, FIFA adopted its human rights policy. And essentially, the FIFA human rights policy basically said that we'll respect human rights. As an organization, we respect human rights. And so this marked an important normative shift in sport governance. But policy commitments alone do not guarantee meaningful accountability. So, lessons from some of the past World Cups. In order to understand the governance challenge, it is important to look at some recent tournaments. Now, across multiple World Cups, we see recurring patterns of human rights concerns. In 2010, the tournament in South Africa, informal traders were removed from the stadium, not allowing access for them to pursue a commercial or be within the commercial zone. They were excluded from actually participating commercially. During preparations for the 2014 World Cup in Brazil, there was large-scale redevelopment projects that led to significant community displacement and forced evictions. 2018 tournament in Russia, authorities imposed restrictions on protest and expanded surveillance measures in host cities. And in 2022, the tournament in Qatar, there was widespread concerns that emerged regarding immigrant labor exploitation tied to the kafala labor sponsorship system. And that was part of the video also. So the kafala type of labor sponsorship system basically said that if someone, say from Nepal, wanted to work on the stadiums, help build the stadiums in Qatar, they had to pay someone money sort of to sponsor them so that they could then get work on these projects in Qatar. And the amounts of money that they were committing themselves to was often something like 5 times what they would make in a year. It was like $1,500, which was an enormous amount of money. They would take out loans, they would borrow from family and friends, because going to work on these projects were often multiple year projects, and they would make 2, 3, 4 times what they would make at home if they were working. So these were really incredible schemes that were going on to get people to go over and work on these projects. Each tournament involved different legal systems and political contexts. Yet the human rights controversies look strikingly similar. These harms were not unpredictable because the same types of issues kept coming up over and over again, all around human rights infringement and issues. They were foreseeable risks associated with hosting mega sporting events. And that is something to note also. This is not just the World Cup. These are all major mega sporting events, the Olympics. The same types of issues come out of those once a host city is decided, and all of the activity around preparing for those events. These same types of human rights issues and abuses tend to crop up. So the governance plan. When we examine these tournaments collectively, a structural pattern becomes clear. Across South Africa, Brazil, Russia, Qatar, recurring concerns have included displacement of local communities, exploitation of workers, restrictions on civil liberties, exclusion of informal economies. The persistence of these issues suggests that the problem is not simply the behavior of individual host governments. So we can't pin it on a particular government, but it is a governance design problem within the institutional structure of global sport. Or, to put it more simply, global sport does not suffer from a lack of human rights commitments. We've seen that's clear in FIFA's statements around establishing a human rights policy. But it does suffer from a lack of human rights governance because nobody is really addressing these issues from an enforcement standpoint. Okay, so in response to these controversies, FIFA attempted to strengthen its governance framework during the bidding process for the 2026 FIFA World Cup. For the first time, prospective host cities were required to submit human rights strategies, risk assessments, due diligence commitments. These reforms reflect the growing influence of human rights due diligence frameworks that are also emerging in national legislation. So with regards to the requirements of FIFA, these human rights due diligence requirements, it's pretty impressive what the host cities had to go through. So anyone within the bidding process, they actually had to go through identifying the potential human rights associated risks. They had to identify a strategy for mitigating those issues. So actually that exercise in and of itself, the fact that FIFA did require that in the bidding process, that really was pretty monumental, and that it was required of all who bid. It wasn't just, a narrow group. So there are many of these examples out there. And the other thing is that you can see the shift of FIFA and the world of sport, if you will, starting to align a bit with what's going on in national legislations as well. For example, the French the French Duty of Vigilance Law of 2017 that requires large companies operating in France that they establish and publish an annual plan to prevent severe human rights violations. And also, the German Supply Chain Due Diligence Act of 2023, also requiring companies with significant operations in Germany to identify, prevent, and mitigate human rights and environmental violations in their global supply chains. And then, of course, the EU Corporate Sustainability Due Diligence Directive that mandates large companies identify, prevent, and mitigate adverse human rights and environmental impacts in their operations and global value chains. So this represents a significant procedural shift in mega event governance. But an important question still remains because there still is a governance gap. So many of the commitments that appear at the bidding stage in the bidding documentation, there's also strategic frameworks and policy reports. However, this is not translated in a way that makes these things enforceable. They're not incorporated in the contractual agreements that ultimately the host countries or host cities have to actually sign. So we're still at they're committing to it, but it's not enforceable. So this presents a potential accountability gap. So several human rights concerns have already emerged surrounding the upcoming tournament. Unlike labor system abuses that dominated debate around Qatar, the concerns in North America are more diverse. They include things like immigration and visa restrictions affecting fans and journalists, labor protections for stadium renovation and event workers, displacement of local vendors and informal workers near stadium areas, restrictions on protest and process. Restrictions on protest and press access during security operations, discrimination risks affecting immigrant communities and LGBTQ plus fans. So advocacy organizations have also raised concerns regarding transparency, noting that many host cities have not yet published detailed human rights action plans. Because again, they had to do the due diligence, they had to state the potential human rights issues, but they were not required to actually have an action plan specifically stating how they were going to address, alleviate, and to actually address those issues. So the enforcement problem, the key governance challenge is enforcement. The primary legal instrument that governs host obligations is the host city agreement. Lynn Carrillo yesterday made reference to that as well. These agreements are extremely detailed. They address issues such as stadium availability, commercial rights, marketing protections, security agreements, but historically, they have included few enforceable human rights protections or provisions. As a result, many commitments remain normative. They remain normative expectations rather than binding duties. This creates, again, that accountability gap or governance gap in the system. So procedural compliance. This creates what scholars often describe as proceduralized compliance. Organizations conduct risk assessments and publish human rights strategies, but without enforcement mechanisms that processes risk, or these processes, I'm sorry, so enforce, but without these enforcement mechanisms in place, these processes risk becoming legitimized exercises rather than regulatory tools capable of actually preventing the harm. So there are some lessons that we can learn from corporate governance. And remember, the UN guiding principles on business and human rights were all actually first envisioned as focused on corporate compliance activities. And so, by the same token, looking at sport, let's step into the corporate world and look at a corporate governance strategy that has been helpful and beneficial in providing that enforcement mechanism that is lacking in sport. So following the major accounting scandals involving companies such as Enron and WorldCom, the United States enacted the Sarbanes-Oxley Act in 2002. One of its key innovations was the creation of the Public Company Accounting Oversight Board. The PCAOB introduced independent oversight of private actors whose activities have major public consequences. And rather than relying solely on voluntary compliance, which is really where FIFA is right now with regards to human rights and issues that come up around human rights, leaving it to the host cities and the sort of a voluntary compliance, and that might even be a little adding a little bit more than they really are doing around human rights. They have the policy out there, but they're really not providing much oversight around those issues. This system established external monitoring capable of enforcing regulatory obligations. International sport has not yet made a similar international leap. So towards enforceable oversight, drawing on comparison, my research proposes several governance reforms. First, that there be binding contractual agreements that are incorporated into the host city agreements, that there be independent monitoring established through the host entity, which is FIFA, and that there's accessible grievance mechanisms that are also involved here. One thing that Lynn Carrillo mentioned yesterday is that there are compliance bodies, that she's part of the legal compliance team. But one thing that is not clear is that human rights is part of what they're ensuring compliance on. I would expect, based on the conversation yesterday, that what they're making sure that compliance is focused on the host city agreements, that people are complying with what is actually in the host city agreements or those binding contracts, not in the bidding paperwork or bidding documentation. So together, these reforms can help to transform human rights due diligence from this procedural exercise, which I see the bidding documentation as being, into something that's more credible and can actually develop and establish a true regulatory system. And that includes the binding human rights clauses, mandatory human rights due diligence, independent monitoring and compliance reporting, and accessible grievance mechanisms. as well as public transparency, which is also part of the UN guidelines on business and human rights. So FIFA as a test, the World Cup, the 2026 World Cup as a test. So FIFA World Cup therefore becomes an important governance test. Some of the key issues to watch include immigration policies affecting cross-border mobility, labor conditions in stadium renovations, policing and surveillance technologies, displacement of informal workers, freedom of expression during the event. So each of these intersects with established protections under existing international human rights law. Excuse me. So mega events operate within a complex structural governance structure. FIFA controls the tournaments. Host governments manage national policy. Host cities implement infrastructure and security. Private contractors carry out much of the operational work. When human rights harms occur, responsibility becomes diffuse. Again, Lynn Carrillo mentioned this, that there are different actors that make up the World Cup. Not everything is done directly by or through FIFA. So there are diffuse actors, which is part of what the problem is. But without, without independent oversight, accountability gaps will emerge. So the central argument then here is human rights due diligence is an important step forward, but due diligence without enforcement risks becoming symbolic compliance. So I've already gone over these, basically these 5 proposed reforms, contractual human rights obligations, mandatory human rights due diligence, independent monitoring and reporting, accessible grievance and remedy mechanisms, and then global sports governance oversight. So in conclusion, if global sport is serious about protecting human rights, the future of governance must move beyond voluntary commitments toward independent oversight, enforceable standards, and meaningful accountability. Thank you. Oh, sorry.
Yeah.
Any questions? Sorry. Yeah. Oh, yes, I'm sorry.
Okay. Hello, Karen. Excellent research and presentation. What I was thinking, it kept me thinking about accessibility, also as a human right. So if you go back to the list of human rights that you have, so there have been developments on accessibility regulation, because the International Paralympic Committee, they created a guide, a guidelines. They have published 2 books in guidelines how mega sport events, the standards that they have followed for accessibility. This includes mobility, visual, ear limitations, and so that is an issue that fits also into human rights.
Yes.
The United Convention,
Absolutely.
United Nations Convention on Disabilities.
Yeah.
And I think it's you have the sources of law there in terms of the United Nations, then the IPC guidance, and then of course this is not FIFA. So,
Right,
but
right.
FIFA can nourish
Absolutely.
from the IPC guidance, because
Yes.
these are the ones that have been used for international events.
Yes, no, absolutely, and yes, I'm aware of what the Olympics has done, which is incredible, and yes, I think they absolutely can learn, FIFA can learn from that. Now, I do want to also make it clear that what I see also is that there's a progression with FIFA. So 2017, it was the policy, so they put the policy in place. Then this year, leading up to the 2026 World Cup, they instituted the human rights due diligence. And now what they've also done is they have, there are two provisions. Let me find my notes. I'll see if I can remember it. So it's labor, they have included in the host agreements commitments around labor rights and, there were two aspects. So I see little bits, they're making progress towards actually incorporating more issues, human rights responsibilities into the host city agreement. But still, even with that, the problem is the oversight, the enforcement. How does the guy in Nepal that's now maimed, ever get any type of restitution, out of this? Because what happens also is that when these human rights abuses occur, the people, if they're still living, because many have died, but many of them can't bring these issues themselves, or they will try to bring the issue, but they can't continue it. So it's like 50 to 70% of the human rights issues go unremedied, and those are only the ones that are reported. There are many, many more that are never even reported, because again, we're talking about a lot of times the poorest of the poor people that can't afford to hire someone to represent themselves. So if we don't have that enforcement mechanism within the structure of all of this, and through associations and organizations that can carry that weight like FIFA, then who's going to do it? We're making billions of dollars off of these these mega events.
If I may, I can share an anecdote and a story to all of you. Again, sport law is not my field. I'm just a fan of sport law and sports, because I see the transnational nature. I practice energy law and I practice in a transnational field also. We do arbitration, international contract, etc. So the world, the transnational application of the standards and guidance, for me, it's a topic of interest. Lex Sportiva as well. My formation comes from the École de Dijon. So I'm very leaning towards the school of thought. But there's a story that I got noticed during the Olympics in Paris. Okay, they have the Summer Olympics and then the Paralympics. And the Paralympics, the ceremony was in La Place La Concorde. And the delegation has to enter La Concorde through the Champs-Élysées. And the Champs-Élysées, the street is cobblestone. Okay, so the IPC, the accessibility specialist of the ICC, regarding enforcement, was explaining that cobblestone was not appropriate for people in wheelchairs, because people will be doing the parade, entering and they will fall apart. And they were talking with the French about, you need to do something to grant accessibility here, and they never make it. And just 3 days before the competition, that discussion came out again, and one of the engineers on the French side, they say, in July 14 that is July 14 in France, La Bastille, the Bastille Days. So we put a screen of asphalt over the cobblestone for the army, but we only do that for very important events. And there are cultural things. And the IPC said, I think this is very important for you. It's the first time you're hosting the Paralympic Games, and you don't want people falling apart. So overnight, they did a cover of asphalt, very thin asphalt that then with the car is all
Go
dissolved.
away.
Yeah.
Okay.
So they cover that with asphalt, and that when you see the opening ceremony, you see the people entering the La Concorde over that thing.
Oh, wow.
But again, enforcement, you know, it's cultural stuff, it's using guidance, what is your enforcement capacity? There's a lot of tension.
Yeah, yeah. But I mean, I think, sorry, goodness. But what Lynn was saying, one thing, I mean, I thought it was impressive, the number of people that are actually involved. I had no idea it was quite that many people, you know, so I'd like to believe they have or can certainly get the capacity to manage compliance issues for something as important as human rights. So, okay, thank you. Do you see yourself, Frea?
Not yet.
Oh, there you are. Slideshow from the beginning. Okay.
Can I do it here or
Oh,
or
yeah. Is it? I don't know.
Yeah.
Yep. Okay, good.
so hello to everybody and thank you for having me as a Belgian here in Houston. I'm already apologizing for the fact that I will not end in 10 minutes as the schedule says,
Sorry.
but I will do my best to keep it short and clear. So today I'm going to talk about the 2025 Serin case of the Court of Justice of the European Union. This case represents a really landmark case in the relation or interaction between sports governance, compulsory sports arbitration and EU law. So in the coming minutes, I will briefly explain how the Serin case in particular, but also EU law and European human rights law are reshaping the transnational authority of the Court of Arbitration for Sports, and how this case law of the EU and European case law will demonstrate the extraterritorial diffusion of EU law through lex sportiva. So international sports is frequently observed like governed by a distinct international, transnational legal order called lex sportiva, grounded in the autonomy of sports and operationalized through the jurisprudence of the CAS. However, European courts have increasingly scrutinizing both the substance of sporting rules and the procedural structures through which they are enforced. As a result, the traditional narrative of largely autonomous lex sportiva is gradually evolving towards a system in which sport governance operates within a broader framework of European legal accountability. So the Serin judgment should therefore not be read in isolation. Instead, it reflects a broader constitutional development affecting the foundations of lex sportiva itself. To explain this evolution, I will proceed in 4 steps today. So I will first delve into the Serin case itself. Then I will discuss the traditional premises underlying the lex sportiva or the autonomy of sports. Then I will examine how these premises have been recalibrated or reinterpreted by the EU and European human rights case law. And finally, I will return to the Serin case and draw some conclusions. Before really going into the Serin case, I think it's good to give a little introduction on what is the European Union. So the European Union functions in many respects as a sort of federal legal system. EU legislation and case law are really binding on all member states, and it's kind of supremacy of national legislation. In many situations, EU law also applies directly to individuals and private organizations, so even companies outside of the EU who are actively on the European markets will be bound by EU law. So at the center of this EU system, there stands the Court of Justice of the European Union, which can be seen as kind of the federal Supreme Court of the EU. This body ensures the uniform interpretation and application of EU law in all member states. So the Court of Justice has already been in many sporting cases because of the fact that professional sport frequently intersects with EU internal market law and the free movement rights. Then the Seraing case, of course. So the Seraing dispute arose from financial agreements between the Belgian club RFC Seraing and a Maltese investment fund. Now, FIFA said that this agreement has been violating its prohibitions on third-party ownership and third-party influence under the FIFA RSTP. FIFA imposed sanctions upon the club, like transfer restrictions and fines. So the club then went to the Court of Arbitrations for Sports, arguing that FIFA's sanctions violated EU internal market law and fundamental freedoms. The Court of Arbitration for Sports then rejected the claim and upheld FIFA's position in this. The club then found an annulment claim with the Swiss Federal Supreme Court, which dismissed its appeal. Now, at the same time, the club and the investment company, they proceeded in parallel proceedings initiated before the Belgian courts of first instance. The club challenged FIFA's rules under EU law, and however, the Belgian courts treated the CAS award as having res judicata, which means binding and final effect, so it couldn't re-examine the EU law arguments of the club. So the club then went to the Belgian Cour de Cassation, the Belgian Supreme Court, you could say, and this Cour de Cassation referred several questions to the Court of Justice of the European Union. In essence, the court was asked whether EU law allows national courts to give binding and final effects to an arbitral award resulting from compulsory arbitration imposed by a sports governing body, when that award has only been reviewed by a non-EU court and cannot make preliminary reference to the Court of Justice of the European Union, because it was the Swiss Federal Supreme Court who did it. So in the Seraing case, the Court of Justice of the European Union identified a structural problem. The CAS award had been reviewed only by the Swiss Federal Supreme Court, which is not part of the EU legal order and cannot refer questions to the Court of Justice. So the Swiss annulment proceedings do not provide an EU pathway, closing the procedural dispute. So this is called the res judicata trap. And this means that the Court of Justice said that RFC Seraing lacked an effective remedy because this is an infringement of the fundamental principle of effective judicial protection, which is stated in EU law, that there must be an EU court that can review these awards. And this was just blocked. In this context, the court also distinguished between voluntary and compulsory arbitration. So while voluntary arbitration may justify just limited judicial review on the basis of party autonomy, compulsory arbitration requires stronger judicial safeguards. National courts of the member states of the EU must therefore be able to verify whether CAS awards comply with EU public policy, including EU competition law and internal market freedoms. So also this court must be able, when necessary, to refer questions to the Court of Justice of the European Union to see if it complies with EU law. The court expressly rejected the idea that arbitration may serve as a means to circumvent EU law as such. To fully understand the significance of these judgments, we need to take a step back. And we need to examine the foundational premises of lex sportiva in the EU. The traditional narrative of international sports governance rests on two premises. The first one is the specificity of sport. Sport is often described as having specific characteristics that are really distinguish it from other sectors in society. Because of these characteristics, the sports organizations have long claimed kind of an autonomy, so minimizing governmental interference. Within EU context, this idea has sometimes been referred to as the sporting exception. In the European case law, this means that the characteristics that render sport specific must be taken into account when assessing to which extent the sport organizations or sporting rules are required to comply with EU law. In the case law of the Court of Justice, this has evolved significantly. The court has consistently held that sports activities fall within the scope of EU law insofar as it constitutes an economic activity. However, in the first landmark case, which is the Walraven and Koch case, I don't know if you ever heard of it, the court acknowledged that certain rules may be of a purely sporting interest or purely sporting in nature, which means that they can fall outside the scope of EU law. This reasoning soon evolved. Rather than creating like a genuine sporting exception, the specificity of sport came to operate as like a contextual factor. The particular characteristics of sports may be thus taken into account when assessing whether infringements of EU law can be objectively justified and whether the relevant rules are necessary and proportionate. So it's just the justification, not the exception. So these rules cannot shield, or the specificity of sport cannot shield sports organizations from the application of EU law as such. While the specificity of sports was in the meantime even legally recognized under Article 165 of the Treaty of the Functioning of the EU, this concept has been given increasingly less impact in the case law. And I will come back to this, but you can already see it on the timeline that it will be evolving. The second premise concerns the authority of the Court of Arbitration of Sports. The CAS was established in 1983 as a specialized arbitral body to resolve all sporting disputes. Over time, it has become like the Supreme Court, or the de facto Supreme Court for resolving international sports conflicts. Through its jurisprudence, CAS contributes to the development of lex sportiva. It is seen as kind of the architect of lex sportiva. CAS operates as an arbitral tribunal that resolves sporting disputes outside ordinary courts. So a dispute may only be lawfully brought to the CAS where there's a valid arbitration agreement. In a sporting context, this is most of the time not voluntary on the basis of a contract, but it's mostly stated in statutes or regulations of sporting organizations. As a result, CAS arbitration is frequently compulsory and rather than voluntary. This raises, of course, some crucial issues. If CAS functions as the only effective forum for resolving disputes without having access to a regular state court, what are the safeguards that ensure that fundamental rights and legal principles are adequately protected? So it's precisely these two premises, the specificity and the authority of CAS, that have been scrutinized by European courts. We can distinguish two trends in case law. Let us first consider the developments in EU, European Union case law. As I already said earlier, the case law of the Court of Justice demonstrates a clear shift in how the courts approaches the specificity of sport. What was once perceived really as an exception, shielding sports from the full reach of EU law, has progressively been conceptualized as a justification element, operating within that very framework. Two recent judgments signaled a recalibration in the court's approach towards the specificity of sport, namely the European Super League case and the International Skating Union case. In the European Super League case, the court examined rules adopted by FIFA and UEFA on requiring prior authorization for the organization and participation in an external football competition in Europe. The Court of Justice observed the question raised by the European Super League case company concerned EU competition law and fundamental freedoms. As regards the legal consequences, the court first referred to Article 165 of the treaty on the specificity of sport. So the court acknowledged that football has distinctive characteristics. However, it emphasized that provisions cannot be interpreted as allowing sport to escape the application of EU law. Instead, the specific characteristics of sports may only be taken into account when applying the relevant provisions of EU law. The decisive issue here was the absence of a clear and transparent framework. So in EU, we can only justify infringements to these rules when we have objective and proportionate criteria in place. And this wasn't the case. So there was a violation. A similar reasoning appears in the International Skating Union case. There, the court examined eligibility rules that prohibited athletes from participating in competitions that had not been authorized by the ISU as such. The court concluded that such rules could restrict competitions if they allow federations to exclude competitors without transparent and proportionate criteria. So again, just as a justification, we can use the specificity of sport. These judgments demonstrate that sport specificity is really weakened during the past years. Also in the 2024 Diarra case, I'm not mentioning this one, but we see that sport specificity really is just a contextual factor rather than really an exception. So sport is increasingly treated as an ordinary economic sector within EU law. In this context, the principle of responsible autonomy emerges. The autonomy of sports is subject to a minimum of requirements, namely the compliance with EU law or the rule of law in EU public order. This principle constitutes a cornerstone, the implications of this International Skating Union judgments even extend beyond the substantive compatibility of sporting rules within EU competition law. It raised a broader constitutional issue, namely the requirements of effective judicial protection. This principle constitutes like a cornerstone in EU legal order, and it ensures that individuals have access to an independent court capable of reviewing awards falling within the scope of EU law as such. At the same time, this system enables national courts to engage in judicial dialogue with the Court of Justice of the EU through the preliminary reference mechanism. The ISU judgment constitutes a starting point regarding the question of compatibility of sports arbitration, compulsory sports arbitration, within the EU framework on effective judicial review. The issue was not compulsory arbitration as such, but the fact that the CAS awards are reviewed primarily by the Swiss Federal Supreme Court, which is neither part of the EU legal system, nor empowered to ensure compliance with EU public policy, or able to make preliminary reference to the Court of Justice. If this pathway becomes the only effective pathway for resolving disputes, the guarantees of effective judicial protection under EU law risk to be undermined. This ISU judgment thus illustrates that there is an important evolution in the court's approach. While earlier the cases focused on the substance of sporting rules, the court also scrutinizes the institutional architecture of dispute resolution itself in sports. Taken together, the European Super League case and the International Skating Union case are really recalibrating the autonomy of international sports on a substantive and a procedural level. And the Serrin case will continue to reinforce this statement. Parallel developments can be observed in the jurisprudence of the European Court of Human Rights. The court has increasingly examined the compatibility of sports arbitration with the right to a fair trial under Article 6 of the European Convention of Human Rights. Before discussing a few cases, it's important to understand that alongside the European Union, there's also the Council of Europe, which encompasses more member states. And this system has human rights really protected through the European Convention of Human Rights and enforced by the European Court of Human Rights. While this system does not form a federal legal order as the European Union, its judgments play an important role in safeguarding fundamental rights across Europe. A key judgment in this is the Mutu and Pechstein case. It's a doping-related dispute that resulted in some suspension and payment of contractual damages by 2 sportsmen. In this case, the court confirmed that sporting disputes that are brought before the courts of arbitration for sports may fall within the scope of Article 6 of the European Convention of Human Rights. This is the case when they concern the determination of civil rights and obligations, such as an athlete's professional career or economic interests like paying damages. The court accepted that arbitration in sport is not inherently incompatible with the right to access to a court, and it even said that the Court of Arbitration for Sport itself can be seen as a tribunal under under Article 6 of the European Convention. Then, when it's seen that the arbitration is compulsory and not voluntary, then full guarantees of Article 6 must apply. So the CAS must fully be okay with all the guarantees that are in Article 6 of the European Convention on Human Rights. Now, in this case, the European Court did not find a violation regarding the independence and impartiality of the Court of Arbitration for Sports, while in the dissenting opinions, there was kind of a different opinion. But in the Pechstein case, the court found a violation of Article 6 of the European Convention because she had been denied a public hearing, which is one of the guarantees in Article 6. So the Court of Arbitration in this case really failed to meet the procedural guarantees required in the Convention. The jurisprudence evolved further in the Semenya case. In this case, the court examined the regulations adopted by the World Athletics concerning athletes with difference of sex developments. So they had to medically suppress their testosterone levels in order to compete in the women's competitions. The dispute had been resolved through the CAS arbitration and followed by a limited judicial review by the Swiss Federal Supreme Court. In its analysis, the Court of Human Rights further emphasized the structural imbalance between athletes and powerful sports federations. Because athletes often have little general choice to accept CAS arbitration, domestic courts reviewing these CAS awards must exercise particularly rigorous scrutiny, especially when fundamental rights are at stake, like the right to privacy of the athlete in this case. The judgment thus shifts the focus from the internal organization of sports arbitration to the quality of external judicial review in situations of compulsory arbitration, embedding CAS within a broader framework of constitutional accountability. Taken together, these judgments really reveal a broader shift in the European understanding of sports arbitration. Arbitration remains an essential mechanism for resolving disputes in international sport and for ensuring kind of a uniform interpretation of sporting rules. Yet, its legitimacy is no longer based on the assumption of autonomy or authority. Where arbitration is compulsory and directly affects the professional activity and fundamental interests of athletes, it must comply with core guarantees within the rule of law. So going back to Serin, this judgment marks an important moment in the evolving relationship between EU law and international sports arbitration. Rather than really dismantling the Court of Arbitration for sports, the Court of Justice introduced a targeted constitutional safeguard. Arbitration itself is not rejected as such. Instead, the court clarified that arbitral autonomy cannot operate as a mechanism circumventing EU public policy, particularly when EU competition law or internal market freedoms are involved. This does not mean that CAS can no longer render final or authoritative decisions. CAS remains the central forum for resolving transnational sporting disputes and continues to play a crucial role in the development of Lex Sportiva. However, the authority and the finality of these awards are increasingly depending on if they are EU law proof and human rights proof. In practical terms, this means that when CAS awards are EU law proof and human rights proof, the intervention of states courts becomes unnecessary. National courts of the member states of EU function primarily as a constitutional safety net, ensuring that EU public policy and fundamental rights are respected. So if CAS panels anticipate these standards and integrate them convincingly into their reasoning, public courts will have little reason to intervene. Seen in the light of RFC Serin, this case law doesn't weaken Lex Sportiva as such, it really strengthens it. The judgment incentivizes sports federations and CAS panels to integrate EU legal principles into their reasoning. Over time, this may contribute to the emergence of kind of a Euro-compatible Lex Sportiva, in which arbitral jurisprudence preserves transnational uniformity while internalizing European constitutional values. So, my conclusions. The broader picture that emerges from these developments is neither one of fragmentation or hierarchical subordination. Rather, international sports increasingly operate within a plural constitutional constellation, where Swiss arbitration law, European Union law, and the European Convention on Human Rights intersect. European courts do not claim global jurisdiction over sports. Instead, it defines the substantial or procedural conditions under which transnational arbitral authority and lex sportiva is recognized and given effect. Within this framework, the two traditional premises of lex sportiva are not abandoned but reinterpreted. The specificity of sport survives, yet no longer as a shield against EU law, but as a justification principle within its analytical framework. And at the same time, CAS retains its central role as the principal architect of lex sportiva, though its authority increasingly depends on its procedural safeguards and the robustness of their reasoning. So in that sense, the future of sports arbitration does not lie in insulation, but in responsible autonomy. A system in which CAS decisions remain final, provided they are EU law proof and human rights proof. And because international sports operates on a global scale and not just a European scale, these European constitutional standards are increasingly influencing the development of lex sportiva even far beyond the European Union. And with that, I want to conclude, and I want, of course, to know if you see this European-centered evolution also in the US, or do you think like we don't look at this, we are just the US and we stand low? Do you have any questions? I know it's a bit maybe difficult because it's really EU-centered, and I know I've talked about a lot of case law that maybe is not really familiar to you. But if you read my paper, I think it becomes more clear. It's just the limited time, I think, to say yes.
No, I think what you're saying is correct. The bottom line is CAS arbitrators have to get it right. Part of the problem is the issues are not well articulated necessarily by counsel for the parties, and sometimes they're not even raised. They get raised after the fact. So it's, on the one hand, I know most European CAS arbitrators like only address the issues that the parties present. I take a little bit different view. If I see an issue that might be dispositive, I'll raise it. You can't just, but it seems like there's gonna need to be more of that, is to recognize, European competition law, European, human rights law, and almost have to insist and sometimes almost go beyond what one of the parties' counsel might be arguing. I mean, you have to give them a full opportunity to be heard, but it's gonna make for, I think, more active CAS panels questioning the parties and making sure that they've had a full opportunity to be heard. And then in deciding the case, going above and beyond to explain the reasoning so that it will survive scrutiny by European national courts. I think that's kind of the bottom line, and I agree with that.
Yeah, I think so too. If they're more active, they will be more trustworthy, because I see these developments in the case law are really like saying, we don't trust you anymore in how you deal with these sporting disputes. We are established for a long time and we know how to protect human rights, how to protect our markets. But you guys, you're still thinking you're autonomous and you're not in this societal structure. So you really need to be more active and more aware of the fact that you're operating within a society. So that's indeed, yeah.
Yeah, just to understand the approach, will the intervention of the European Supreme Court here will be only for cases involving European citizens, or this also apply for, let's say, an American player that enters into a case in CAS and then the award is challenged? Is that the same?
Yes.
Or
Yes. In principle, EU law is only applicable to European or EU citizens, so therefore it will be only applicable to them. But if you see, the CAS has its seat still in Switzerland, and the European Convention on Human Rights, they just use it. So whether you're an athlete from the US, from an African country or an Asian country, still, if you come before the CAS, it's still Article 6 of the European Convention of Human Rights that will be applicable, because we've seen in the Semenya case, she's a South African athlete. She has nothing to do, even the sports federation that she was in was not in the EU, and still it was applicable. So I think there will be a far more broader influence of EU law to the rest of the world. However, it's not really, if just an American athlete with an American federation brings a case before the Court of Arbitration for Sports, probably there will not be an EU law reasoning in this. But still, because of the other cases, these federations will adapt, and the CAS arbitration will adapt or has to adapt. So I think over time, there will be an influence on every case all over the world to this. And what is really something important to know is that I think UEFA has now in its regulations said that there's a seat in Dublin that's really doing European law and European Union law, and not as just how do you call it, like a satellite, but really a seat. So really using European Union law in CAS, and that CAS arbitration will be just need to apply EU law. And that wasn't the case when it was only Switzerland, because it's not in the European Union as such. So there was only the review of the CAS awards. But now when a CAS is seated within the EU, it will be even more into this. I'm sorry for my English, it's not always.
No, you're doing great. Questions? Right?
Thank you.
If you wanted to. Okay.
Just keep it seconds, yeah.
No, I don't. I think I gave you the one, but I'm gonna change a couple of it because I know that was the one minutes. I have. Oh, did you? No, this is the one that you just put it up there yesterday morning. Yeah, it's the one, the last one. Okay, well, great. Well, thank you. Thank you, Matt. Thank you, Freya. Wonderful session. And so we are just about 15 minutes from the scheduled lunchtime, but I'm going to ask you to indulge me for about 5 to 7 minutes, depending on how quickly we can pull it up, because this is the first surprise. Okay, so there is a podcast that is listed in your program for this time, but that podcast is available to you on the website as well as others. But one that was more recently posted, you might not have seen, and it is actually with, and Julian's going to help me out,
Curtis Franks, General Counsel for FIFA World Cup. So we had yesterday Lynn Carrillo, who worked on the legal division of FIFA organization. So FIFA organization creates FIFA World Cup company, organization in the US to run the FIFA World Cup. And Curtis Frank couldn't make it to the seminar, but he was kind enough to record a podcast in which I made a few questions about his practice at FIFA World Cup and also about his career.
Perfect. Okay, so that is the surprise. It runs a little over 20 minutes. So lunch is delayed by about 5-6 minutes. So we're still pretty much on time.
Hi, my name is Julian Cárdenas, and I am the director of the Center for U.S. and Mexican Law at the University of Houston Law Center. The center is supporting the organization of the Symposium from kickoff to consensus, the 2026 FIFA World Cup and North America cooperation, highlighting the importance of cooperation between the United States, Mexico, and Canada in the organization of mega sports events. This is another episode of our series of podcasts interviewing experts in the field of sport law. Today, we have a special guest. It's Curtis Franks, General Counsel of FIFA World Cup at FIFA, a graduate from Tulane University who agreed to speak with us about the legal aspects of the organization of the 2026 FIFA World Cup. So thank you very much, Curtis, for being with us today.
Hey, thank you for having me. Glad to be here.
Well, Curtis, first of all, we're very impressed with the work that you do. In the sense that being in the legal practice in the organization of the biggest sport event in the world has to be a remarkable experience, a breakthrough experience for you. Also, for this Soccer World Cup, there's a record number of teams, record number of matches. The host countries are 3 nations, Mexico, Canada, and the US, as we mentioned. So I imagine that you deal a lot with adapting national regulation or practices with FIFA standards. So can you tell us a little bit more about your practice for the Soccer World Cup?
Yeah, so I'm the general counsel for the World Cup. So I have just a responsibility for everything legal associated with putting on the tournament. So that is across all 3 countries. So I have a team that sits here in the US, but also have a team in Mexico and Canada as well. And really, we ensure that we work across all 3 countries to execute everything that's we're responsible for the tournament. So that's everything from our contractual relationships with the stadiums, our contractual relationship with the host committees in each of the 16 host cities, everything that needs to happen. So that is immigration, getting people in and out. That is customs, getting equipment and things in and out. That is employment matters that happen across all 3 countries, hiring and ensuring that we're in compliance with some states in the US and Mexico and Canada from a wage and employment standpoint. We deal with those issues as well. Everything from training sites to where our teams are going to stay. So we kind of manage the legal contractual relationships with those training sites. And then just a host of logistical items of moving equipment, people, goods, services, and things like that around the tournament, as well as also what we deal with. So if you see something that's happening within the tournament, at some point, my team or myself, we had a touch point into having it because we kind of handle everything from a legal standpoint. So And so we really, and I always preach with my team communication across all three countries because there are a lot of nuances that happen. So it's not just that you're dealing with one tournament, you're dealing with one tournament across three countries.
Mhm.
You have a tournament that is in various different states in the US, it's in two different states, in provinces, three different states in Mexico, two different provinces in Canada, and across 16 different cities. And so that's a lot of jurisdictional kind of, legal frameworks that you have to work through. And unlike previous World Cups that were, maybe in Russia and Qatar,
Mhm.
these are not, these are kind of democracies and not kind of autocratic places where one person can kind of make a ruling about everything that needs to go. These are also kind of federalistic, democracies as well, in which you have kind of federal governments in each one, but then you also have state and local governments as well. And so one entity can't just make a decision on a lot of things that are happening. So, for example, the federal government doesn't really have to do anything to do with the permitting and the things that we need to do at a local level to what we need to do. But the federal government does control the immigration and the customs allowing things in and out of the country. So it's a little bit of a nuanced aspects of things that we deal with here. So for us, it's all about making sure that we are, as much as we want to stay consistent across all three countries and kind of put on the World Cup in a way that has been done in the past, we do have to adjust for the legal and local landscape that we have. And that's kind of what my team does and manages on a day-to-day basis. So.
And you have been involved in the organization for how long?
So I started in 2023, so we're coming up on 3 years where I've been here doing that. The first 6 months was just me before I had the opportunity to just hire a team.
Okay.
And now we've grown to a total of about 21 folks, about 18 attorneys, and then a couple of law clerks and legal and paralegals as well. So.
And Curtis, in the celebration of the matches, you have to deal with the stadiums in the three countries. These are stadiums that are world-class stadiums, I imagine, right? You pick the best that the countries have in Mexico, Guadalajara, Monterrey, Mexico City, Canada, and the US. So, but despite the fact that these are world-class stadiums that normally they host international competitions, do you still have to work with them applying FIFA standards or practices for these for the Soccer World Cup?
Yes, definitely. So, especially with a lot of the stadiums in the US, they're not really FIFA compliant with the measurements and standards for how a legal pitch is and then the specifications for a pitch for the World Cup. So, a lot of the stadiums in the US have had to have made modifications. They are basically built for American football, the size and kind of the shape of what that is. So, there have been a lot of bold modifications that these various stadiums have had to make in order to kind of comply with the standards that we put in place for a World Cup. So, that's expanding, removing seats, making seats more, temporary, move some things out. There are also kind of other little things too. So some of the stadiums, particularly some of the smaller ones, may not have had the necessary little things like concessions. So we require a certain number of concessions outlets and things like that. So they've had to either build in concessions areas or essentially bring in temporary things to kind of comply for that. So we work with the stadiums a lot to ensure there was a lot of specifications that were put out during the bidding process where all the stadiums were there. And then once the stadium said, yes, we agree to make those modifications, we've basically been working from a compliance standpoint with those stadiums to ensure that the stadiums meet the specifications that were listed out in the bid. So for some stadiums, it's easier because they kind of made those things, but some of the older stadiums, not so much. So an example of that, the older stadium would have to make a lot of modifications and some renovations is in Mexico City, Azteca, that had to be kind of changed and modified and did some things that from the amount of suites to kind of the pitch modifications and everything else just to make sure that it was in compliance there. And, even in Toronto, it's a smaller venue that we have there. So they've done a lot of modifications there to basically expand in some ways to kind of make sure that they are compliant with the specifications that we have there. So we work with the stadiums on a consistent basis to make sure that happens.
Very interesting. And Curtis, when you deal with local authorities, are you dealing, your counterparty will be a government organization dealing with FIFA? Do you deal with contractors? Is the local authority, the local agency dealing with the contractors to comply with this?
It's a little bit of both. So we have in each of the cities where the 16 host cities across North America, there's a host committee that is a part of that. And we usually work a lot with that host committee, and they're responsible to just helping us kind of navigate things locally. So that's local law enforcement, that's local governments, and that's kind of local contractors and what we have there. So, but it really just depends. It depends on what some of those obligations are the host committee's obligations. And so it's their responsibility to do that. We're just kind of making sure it happens. But sometimes some of the obligations are ours. So, for example, if it is something that we're going to do at the stadium where we need permits or things that are going to happen because of some activity that we're conducting, a lot of that's going to happen in our hospitality spaces. We're building out additional hospitality areas in and around the stadiums for the World Cup that they're not necessarily there with the stadiums. We have to get permits and things like that. We will manage that process on our end. The host committee or the stadium folks will put us in contact with the local folks there, but we kind of manage and handle that process. Whereas other areas where the host committee may be the ones that are doing it is like really kind of they're responsible for the safety and security things. So local law enforcement and things that are going to happen there, they're responsible for those costs. Those are things where the host committee might take the lead. We'll be involved because we do want to understand from a safety security standpoint what's going on and how it's going to be integrated, but really that they may take the lead because they're ultimately responsible for that obligation. So it really just depends. Depends on what the situation is and where it is, about who parties there. But the goal with all of this, it wouldn't work unless we had coordination between ourselves and the local host committee that's there, and then the interaction with the state and local government. So it just really just depends. Sometimes it's us, sometimes it's them, and sometimes it's all of the above. So
I see. This is more a personal type of question, but I imagine other people will be very curious. Do you do the inspection of these stadiums? Like, it's amazing seeing them when they are full, but also I imagine it's amazing seeing them empty when they turn on the lights and you see how magnificent they can be.
yeah, so my team and the legal team doesn't necessarily make sure that we will be in conjunction with that, but we have a whole venue operations team that does go in and inspect. So they go in and they ensure that the pitch is basically up to specifications from a sizing standpoint and doing that. So they do kind of work with the stadiums to make sure that happens. We do have a whole so the thing about it is we're taking over the stadium. So each of the stadiums has to provide us the stadium free of all third-party rights. So we go through the stadium and we make sure that all of those third-party things are removed. So third-party rights being, so there's in North America, there are a lot of commercial activity that goes in the stadium. So there's a lot of signage, there's a lot of commercial branding that happens there. All that has to be removed. So we do kind of just make sure from a compliance standpoint, all that happens. There's a team that manages that. And then even from a ticketing standpoint, we've gone into each stadium to just basically count every single seat to make sure that the manifest that they gave us actually matches those things there. I mean, you find discrepancies and you see where it is, and then you make the adjustments to the overall manifest to ensure that the seat is there. Because what you can't do on our end, we can't sell a ticket and when the person gets that seat doesn't exist. So we actually do go in and have people go seat by seat to ensure that that manifest matches and those seats match. So there's a lot of work that goes into that and a lot of things like that when we can basically support that from a legal perspective.
I can imagine. I mean, sport law is not a part of the curriculum of many law schools, right? Probably it's very common in Europe and also here in the United States. But what led you to get in connection with these mega sport events?
Yeah, so I guess it starts way back for me. My very first job when I was 16, I was born and raised in Atlanta, and the Olympics came through in 1996, and I just turned 16, so I was eligible to work. And my very first job that I had was working at the Olympic Stadium during the Olympics. I was working for Coca-Cola, and it was my job to just fill vending machines and coolers in the suite area and VIP areas. Absolutely loved that job and caught the bug of like, man, you're actually going to pay me to go to sporting events and do that. So I would always make sure that I paid, that I basically filled up my job and did what I need to do, and then I could basically go out and watch the track and field events that were going on. So I kind of fell in love with it then, and I thought I was going to be an orthopedic surgeon. I was going to be a team doctor. Went to college, took organic chemistry, and found out that I was never going to be a doctor because I just failed at it. So. Really, I made the decision late in college to go to law school, and I knew I wanted to kind of stay within sports because I know that's what it was. And so I chose Tulane University because they had a sports law program, and I went to Tulane and got a sports law certificate from them because they have a curriculum focusing on sports law. And then from there, just took off from there. When I came out of law school, I did not want to go to a law firm. So I just kind of bet on myself and took an internship with the Atlanta Hawks when I came out of law school. It was only supposed to be a 3-month internship. A couple of things happened. I got a little bit lucky. Lightning kind of struck me and hit me. And I was able to, they kept me on because of, they had an opening for me and they liked the work that I did. And I was able to move over and to get a full-time role with them. From there, I left left the Hawks and then went to Coca-Cola, where I was in their sports and entertainment business affairs group and just did sports and entertainment transactions in their college and university space. Then after that, went to NBC Sports. And then after NBC Sports, went to the NCAA, where I was kind of doing all of their championships and their corporate partnerships and media relationships and managing their IP portfolio. Then had the opportunity after that to go back to Coca-Cola, where I was the head of the sports and entertainment legal team and managed everything from a marketing and sports and entertainment thing from a legal perspective at Coke, and was working on the other side of the table at FIFA. So I was managing that relationship from a legal standpoint. And then FIFA kind of inquired about me and asked me if I wanted to come over to work as the general counsel here for the World Cup. And it was a once in a lifetime opportunity for me to do that.
Absolutely.
So I just took that opportunity and left Coca-Cola, which was a good job that I was loving and doing a whole bunch of things with, not only just FIFA, but the Olympics, the Grammys, everything related to kind of sports and entertainment that Coke does. But getting a World Cup was just a once in a lifetime, rest of the generation opportunity for me. So I knew I needed to do it. So that's kind of how I got here. So for me, my career has really been, I knew I wanted to work within sports because that's kind of where my focus has been. I kind of focused in on that when I was in college and in law school. And then just, heard a bunch of no's, but just got the right amount of yeses to kind of just get myself to the right steps in things in my career here up to this point now. So
pretty amazing, Curtis. For students and young lawyers at this time, we're 2026 now. What opportunities do you see for them to get more experience, to get involved in sport law? Highlighting that this is also a practice that they can exercise, corporate law, the business law, litigation also. There is the CAS, the arbitration court in Lucerne. Right, so there are many issues that they can practice. IP, right, that exists in the field. So what would you recommend to young students or young professionals to get more involved with this practice?
Yeah, for me, one, I just think too, you gotta have the passion for it. So just one, if you really have the passion for it, you go for it, just understand that. I think when I do interviews with folks, I can kind of tell if you really have the passion for it or if you just think it's just a cool job and you just kind of want to just do it. So really, if you're exhibiting the passion in that things, like start there. I think two, learn the sports, the sports ecosystem. And I think when I hear a lot of law students come out of law school, they're always just kind of focusing on like a team. I got to go work for a team. And that's kind of what they think from a sports law perspective. But the sports ecosystem is vast. So learn the sports ecosystem, all the things that go into it. So there are sponsors, there are media partners, there are sporting agencies, there are all kinds of things that support and tap into the sports ecosystem. So for me, Coca-Cola is a major sponsor and they have a whole, work stream that they have from that. Their focus is on beverages and selling beverages, but they sell beverages and market them through sports, using sports and entertainment. There are a bunch of companies that do that. So if you're at a game and you're at a match and you just kind of look around and see all of the signage and things that are going on, some lawyer had some touch point to that. So kind of think about that and expand your horizons beyond just working for a team or just there. Think about agencies, think about unions, think about all kinds of things that tap into those things that will help. And I would say the other thing is just like be ready for the no. Like you're going to hear the no a lot just because everybody wants it. You can have the passion for it in the background, of course, but you are also competing with everybody else that thinks this is a cool job. But don't let the no discourage you. Like if this is something that you want to do, just be, really kind of keep your head down, keep doing it and kind of going after it. And eventually you'll get the break if you really are dogged about it and going after it where you want to be. The last thing I want to say is like, hey, look, just remember this. I always tell people this on the other side, like when you're in sports and everything else, unless you're on the field, you're not making big money. So if your goal is to come into this thing and make a whole bunch of money, then you probably should go to big law, kind of go through things like that and get where you want to be. But like, just understand, like you are kind of like at a point, this is more about, this is what I say about the passion part of it. the passion part. I understand that because for me, until you kind of get to more and more senior levels, you're really kind of making below market just because they know everybody wants these jobs and you want to do it. So kind of go into that with that mentality too, that this is not what you're going to make a whole bunch of money, because it's just not that. If that's your goal, you should probably go to a firm, do the things that you need to do to kind of get your money and maybe come back around to sports on the back end where you're a little bit more senior. But if you're just kind of coming in there and on the bottom level, just understand like it is not basically this lucrative thing that you're coming out to do, because the people who make the most money in sports are the folks that are actually playing it, not necessarily the people behind the scenes doing the actual administration and things on that one. So
yeah, Curtis, but I can see the huge value of the work you're doing, because billions of people will follow the World Cup, and it will be a real opportunity also for the United States to get soccer programs being improved, and their participation in these international competitions also place the United States in a better position. But you're making history by doing these type of events, right? It's every 4 years, and kind of the world stops during the celebration of these matches, right?
yeah, exactly. Yeah, so that's the passion point behind it. That's what gets me wanting to be involved with it. Though that kind of just interaction, that passion we see with the fans in there. It, like for me, there's nothing like walking into an empty stadium when no one is there. Kind of that gives me a rush when I kind of see those things. But it also gives me a rush when I see that they fully impact and the event is going on. So yes, I agree with you. Like that's again, that's one of the main reasons why I took this position, because it was a once in a lifetime opportunity to come on the world's largest sporting event ever. Just kind of be associated with that, and I had a big part of that. It's something I'm going to take I've already taken a lot of pride in, given the work I've done so far. And I'll take a lot of pride in as we go through the actual tournament as well. So
absolutely, and you should. So Curtis, thank you very much for being with us. And we hope that this conversation will. It was very informative for sure, but also will inspire students and young professionals to get more involved if they're interested and have a passion within sport law. Okay.
Hey, thanks. Sorry I could be in person. My schedule didn't allow it, but yeah, thanks for this opportunity for me to guys talk to you and everything. It was great. I enjoyed it.
Thank you so much.
Thanks.
The video and now the nice music. But with that, lunch is served. Yes. Oh yeah. Yes, I know, exactly. So
we can post.
Dile, no,
From Mexico.
yes.
We have law, the whole package. We need to explore this.
I asked.
12:30, so I just had a muffin. I'm like, oh no. I might just pop in there, but yeah, probably. It's, but yeah, it's probably.
So that is for slow later.
So you go all the way to So this is
Yeah,
45 here.
so how many students Brian has in this class?
45.
I can check. Let's see, I think it did it.
Yeah.
Well, good to see
see you.
Journal was sponsored by the students. They were traveling for the reference, so make it.
Yeah.
We had a.
What's the your machine?
Okay.
I'm sorry to interrupt you.
Yep, you'll be first.
Okay, so if anything, goes late, I just wanted to be able to just match us. My airport is.
And you going all
Oh, you're IH?
downtown
Yeah.
north.
Yeah.
Well, at least it's on Saturday. Hopefully it'll be at a,
Yeah.
but still,
Yeah, it's the last flight to go home, so I just want to be sure.
you-
So
you
anyway,
Probably, you want to give your presentation.
okay, so that's.
You should probably. Because that was,
Choose one intercontinental.
I'm pretty sure, Sure wasn't.
It should be okay.
And on a Saturday, so it should be.
So I can just get Ubers or easy
Oh,
to
yeah.
get here.
Oh, yeah.
Okay.
We'll pick you up here on the side.
Yeah.
Wonderful.
Yes, you'll be fine.
Thank you. And lunch is.
Oh, yes.
Next one.
Oh, I'm
Okay,
sorry.
yeah, the buffet is, you have to
Yeah,
go
you can
Oh,
go
wow.
out.
left.
Yeah, there's
okay.
people out there that will help guide you.
Yes, likewise. I'm gonna be heading off in a bit.
Oh, all
'Cause I've gotta-
has been done.
Yeah, I gotta head and fly back.
Oh,
Luckily, I'm going out of hobby.
yeah.
Oh,
10
that's
minutes,
great.
if
Yeah.
that.
That's the benefit of having lived here for 10 years.
Oh, yeah.
It's like, what's up? But yeah, I've gotta get back. 3 o'clock. But so I'm gonna give it plenty of time and it's like spring break is over.
I know.
It's gonna be, Monday
See,
morning.
and we're
For
just
you?
starting.
Wait, go, we're just started.
Yeah,
Oh,
next
yeah,
week,
yeah.
even though it doesn't mean anything. This
Yeah,
means
I
less
know.
students around.
Yeah, it was nice to have, but I have 2 Monday classes, so I'm up at 4:45 to be on the 6:10 train.
Yeah, what do we do?
I got home to
Yeah.
Well, because I had told them 3 years ago this was going to be my last year as a clearance. So they brought in someone who could, pick up the torts class and antitrust and the DOC. So I picked up business students. I started practicing. Interesting.
Uh-huh.
I mean, because it's got a federal and all of this stuff, and I was like, oh wow, God, that is fun. But then I decided to stick around for 3-4 more years. So anyway,
Oh, sure. Yes. No, come on.
You guys did all the heavy.
Oh, you Mitten, how are you?
Yeah, would you?
I got faith. That's good. On down to all.
lack of governance and real enforcement of the regulations. There's interesting content. We are big soccer fans, so everyone was different. Somewhere if you're like the US person thinking it's us, I guess, like we look at the soccer. Comparison to soccer.
There will just be so many games. And when you increase the World Cup to 48 teams or whatever.
Like games like that here at the football field, so we sold out. Like Mexico comes to town. It's like kind of hoping to get them. If the risk of going.
It's way too expensive to go to that game. If it would be as expensive, maybe you would say, oh, I want that.
Yes, they do.
¿Cómo hacía para
Oh, okay.
That makes sense. My email,
Yeah, exactly.
my email.
Are you
gonna change the area?
I'm trying to be safe, trying to find a job. I'm finishing in May,
Okay.
I understand.
and I'm trying to.
Again. The prices are gonna be from the amount of.
Yeah.
So you have a sport law program?
We have family members that have gone to.
Yeah, ours is a lot bigger.
Is there a specific focus on oil and gas?
We have like 12 courses and about 100 sports.
In my case, what I'm.
Yeah, so we have,
Like that. Well,
ours was actually founded
how about I was
at the same time as
I don't know, maybe all
Tulane, 89.
So that's
Goes back. I wasn't there then, I joined
Any
the
its own way.
faculty at,
This is a project going on.
but I know Dave Feldman very well. It's actually good that there's multiple, I think Tulane and Marquette are the only two
Yeah.
sports
You
laws.
never know where you get to be.
Well, what for these kids?
Yeah.
Are there specialized
that,
courses in, say, solar?
I always delight in telling my students, I never took
different
sports law.
oil and gas, or is
We had a course.
Excuse me, everyone. So Cheryl was nice enough to point out to me that I actually started lunch about 30 minutes early. So all of you, if you wouldn't mind putting your food back, no, I'm just kidding. No, so I know that some of you need to get to the airport. So are you guys okay if we start at 1 o'clock instead of 1:30? And then we'll finish at about 2:30 instead of, I think on the program, 3 o'clock. Okay? Okay, great, thanks.
Okay, so I was what I would call a trade regulation. I trust non-technical, like it's trademark
Yeah,
and
that's
fair
smart.
competition. Back then was interesting, NIL rights.
That's right.
So I practiced with, he's Atlanta-based, it was Kilpatrick Cody, now it's Stockton. Patrick Townsend. So it turned out that and economics degree were good background for sports law. Then I started teaching. Torts was my 1L course, and everyone else, my family's medical side, and I started doing. I
You have like these.
kind of a predecessor to the Americans with Disabilities Act. Did those sorts of things. I could an athlete insist they play with a cardiovascular condition or whatever, and started doing a lot of salaries, health, and safety things, and then Marquette was on the NCAA's competitor safeguards medical aspects of sports. So we did the doping. Yeah. That's kind of how I got on the cast, because there a lot of cases we see doping. So So the NCAA gave us great training because we would tour the audit accrediting labs in Minneapolis and Los Angeles. So they actually taught us how they test for all of this advanced substances. Apparently, it's all based on timing. Like certain substances showing up on a graph X amount of period. That's kind of how they identify them. And then they have all the audit accredited labs to maintain the integrity. They have PhDs from all over the world, not the US. It's not just the US. And they explain confidentiality. There's just probably 70 pages of documents that accommodate one sample. So, making sure that, this person goes all the way through. So yeah, it's kind of, I would have never expected I'd end up but a lot of it is antitrust. Copyrights, trademarks are a huge source of revenue. At bottom, most sports disputes are
Ansley growing up and when I was
usually
private practice,
some sort of,
NFL.
even if it's a human rights issue, at bottom, there's some sort of
Kind of exposed.
First time I heard about he's a professor at the University of Florida. And was an arbitrator Simon was taking care of the Florida tournament at the University of he's a soccer French soccer player. Michelle Platini, some study at the
So what she
a lot of
so she talked to us so they're gonna actually start
my research assistant, Ryan Miller, very bright woman. I never really thought about it. But a lot of people come in, they think, oh, I would do well in sports. And they get a big surprise because and I guess the internal governing legal regulations do like some Olympic and so we cover different areas. High school sports, governing body, state actor, lots of all the NCAA's
I'll just take some of these.
So it's a good review. They get used to antitrust. I tell the students, I can make a very good argument that these two courses are easily among the top 3 most difficult in the law school, with the exception they have to learn some international law. We actually have in terms of what is which is really important because the NBA probably having a satellite league, we're trying to set up league over there. Baseball kind of expanded. Like it's good with Monterey. This is the first year co-teaching folks for baseball. It's actually going to be 90 It's been fun to have, the only commissioner that's a baseball Milwaukee and then he's been commissioner. Labor issues and all that. So I've learned a lot. Here's how you get consensus. Share with It's a big story. Yankees are But yeah, I think they're talking about expanding in like Mexico City. Because they'll go to 32. Well, put it there. They'd like to put another one back in Montreal, but you got to have stadium.
Yeah, I was surprised.
That's the two key pieces.
They would be grosso, right? They play
Use
grosso.
it, I mean.
Yeah. But he said that's what you need to have the financial stability and support.
Media about renewal.
Stadium.
Remember in Beijing, the Winter Game,
Here, our house, she was here. There's a lot of renewal stuff going on, which makes sense. I mean, you're in the south, you got the sun.
the other day.
Rally
The medicine. That's that positive.
You get some really strange stories. And I think that was actually difficult legal issues because she was only 15. She would have been older than her, so she was considered certainly.
I didn't want to
There's lots of and so she was a
not in favor, and now I'm in every time. I'm like, hey, we are selling back, and so
later they found it. They didn't accept it. If that was the source of the the claim was that she, it wasn't her grandfather, it was someone she called her grandfather. And there was this dessert, frozen dessert that he made, and that had the substance. But it was like, wait a minute. The claim was that she took it with her on a train from Moscow to St. Petersburg. Sufficient amount of it that it would deprive negotiation. I believe it was 4-year suspension, and they had another just you hear all the one of the more interesting ideas was a tennis player. He was able to prove the source of it was when I grew up in Miami, had a woman who was a stranger. She was doing cocaine in the ladies' room, you know, some deep kissing and things. And well, I wasn't. I did not know that she was using cocaine or test positive for it. And he convinced her, you know, he was able to more likely than not. But you said some of the strange, you know, when I did some NCAA drug test appeals for athletes saying, I never used marijuana because that was on the but I was at a party. Everyone else was smoking. So it's second-hand smoke case. There'd always be an expert. So it's the Canadian head of the Canadian. She heard it and she said, that is what it goes, it wouldn't test that time. So then he goes, oh, my family is always
Because one of them is moving your head.
and she said, again, you know, your concentration could not resolve that. And then he said, well, my dad was that. So we don't know.
Yeah.
Yeah, I mean, I think it's very interesting you say because I've never been outside of you know, from the price.
Tennis championships
I
in Georgia.
You took pictures that high.
Salad corn bun. Sit down to someone, normal serving. She said, you just can't get there. And he said, well, I took the rest of it with me. So he claimed he took potato salad and corn.
Not have access to.
Ate it. And it's in mid-June. that level, which is probably a 2.5 hour match, so we rejected it, we just were like, we don't think so.
And then you will have
Yeah, you
Mahogo.
get
And then you will have
all sorts of, we had a baseball player, and was trying to show he wasn't involved in the substance abuse, and he accepted this expel. He wanted to be an FBI.
You know,
He knew he'd have to disclose
and the
it.
people
He said, if I
want
was
to start off
on my record,
with you,
that may well
you might end up doing something else. You know, you just never know.
I'm trying to think what happened on that one. But that might have been one where we actually believed it. Unlabeled. The problem is, too many athletes think that you can go to GNC. If it's available over the counter, and that's not chili. You can get stuff. Or you'd have people that would go to spring.
You know,
Go down to Mexico and just take whatever old people said, well, I have an older brother or sister who's an NCAA athlete. They gave it to me and they wouldn't give me anything else. So most of them were
One job in the world, somewhere.
just not doing their diligence.
There's other
My
things.
wife was a swimmer for Team USA in London in 2012. And when we saw the news and see these cases of doping, she explained to me that athletes, they take care, they're very rigorous about everything they put in their mouth.
They should be.
I mean, the intention that they have around them, that doping, that's not a problem.
If you're competing at that level, you're subject to random tests.
Yeah, they're not gonna
And you got
take
disclosure
your
whereabouts.
It was the deal
And-
was the first 20 steps. And they already told you.
And you get to that level, you know, don't take it unless you check it out. You know,
Oh,
there's a center for sport, but things are mislabeled. And you gotta do some research to see if there's been any reports of it. My bottom line is, if you
Oh,
take
that's right. I forgot. Yeah, we
your
just
system,
Curtis
competition results are
Yeah,
validated.
I was trying to switch
There's
it
suspension from competition based on level.
as well.
So you just say, what would a reasonably
Yeah, very high up in World
specific
Cup.
circumstances and
That's
been the precedent, you can make it.
Y hay varios doctorados.
There's this famous story from Italia, 1999, the Soccer World Cup in Italy.
It's gonna go to NRG.
There was this playoff game
I don't know.
between Brazil and Argentina.
I'd say around the 60s.
And at that time, there was a common practice that if somebody was scored in the game, and maybe softball,
Raised in Chicago area, so I
and
lots of
so they
Midwest.
bring water out to the soccer players, they share a bottle of water. Apparently, the doctors,
So I'm gonna have to leave before you go to the airport.
they give them only those bottles of water and came with black sauce. So this is very, that's a rumor that's late. The Brazilians complain to Argentina, oh, you know what?
They will that stadium for this stadium for that city. They're not gonna be referred to as.
That's an area of law.
Good for you.
Well,
Right, I know.
in the DC area, and I had it by the time I got there.
Oh, and, you know, pretty much every area of law is supposed to be courtesy.
And there's a lot of money, big deal.
Yeah.
One of my students is general counsel for my
Right.
Hey, remember, no, not here.
They're the owners of Bill
Remember the one?
And then retail, very important.
Yeah.
And Mike said, he goes, I've been a real estate lawyer the last couple of years. It's like all of the stuff relating to construction, sports facility, and all the other things, because
In Baltimore,
August 1, revenue reduces.
I have no idea how it works. They love it.
You know, my dad's on work, and you're doing as cities, for it.
I love taking the ball.
It's like, it's hard to think of an area of law that's not.
So wait, I gotta get rid of
Remember trying it out?
you get tax issues.
Well, Messi had tax issues in Catalonia in Spain.
Yeah, because you have like golfers, tennis players, all over the world.
My brain makes sense.
Every country say, hey, you owe us money.
I don't have the
Yeah.
bandwidth to
Tax your income.
very much a gentleman.
And they have, of course, lawyers, accountants, and
Oh,
make
yeah.
strategies, tax efficiency, and then the government comes down and does tax efficiency. That's the basics.
Yeah, it's,
There is a woman.
every area of law. And then, sales franchise.
Oh, they do
You
have
get
it.
family-owned franchises that, was it the
Oh,
Mara family in New York and Betty's, the Mahaskis owned the Bears. The value of the franchises is in the billions of dollars. And they went into very serious estate tax planning. Because even if they have kids or whatever, they can only give so much.
New York City in just a few hours,
Estate tax,
rest on
if you bought a
the
franchise, it's worth maybe 10 million. And now it's worth, like the New York Yankees, George Steinbrenner, paid $10 million. Now they're probably worth like 6, 7 million. So you got a big estate tax issue when the principal owner's passing away and it's staying for the family, and they're selling 10% shares and people are buying it for like 500,000 or $1 billion. I mean, it's, yeah, it really is. I don't deal with those issues much, as you might imagine, because I have that kind of money or the expertise.
So I was talking to a colleague who's also a lawyer.
You kind of had to get in early. We were lucky on the East Coast that those tracks were
How much
there a long
like
time
in
ago, so
commercial
we can
debate.
speed right
Sometimes
up
you have
to,
to do
you
something
can go.
within a competition, so within the Olympics, within the World Cup, something like that. So you have days, sometimes even hours, or if they issue with the career of an athlete. So athletes have maybe careers that have 15 years in a career in sports. So you don't have the time to say, oh, these athletes can be out without competing for 2 years and here's the age. You don't have a comeback.
Oh,
You do have to work.
I mean, some with steroids.
Even though I didn't
Right.
take sports law, the best thing that I did that compared to
Oh,
sports
within the state,
arbitration
okay, that makes
is
sense.
I did a lot of TRO and
Yeah.
preliminary and
Yeah,
injunction
so
work
that's all well
on behalf
established,
of
so that's.
clients and IP issues. So we'd represent a franchise or a franchisee would be terminated and they continue to sell McDonald's hamburgers or whatever. So it's the same thing, substantial likelihood of success on merits. So that was the quickest I had to decide in arbitration. So I was out by the pool. This was a couple summers ago. I got a call from AAA and they said, hey, we got an emergency case. And I said, well, define emergency, we doing a hearing tomorrow? And she goes, no, we're doing it starting at 5. And she said, it'll be a 2-hour hearing. And then
There's
I had
always,
to render a
somebody's got an
decision
interest somewhere, yep.
9 o'clock because there's very strict rules when each country has to enter its team. So this was track and field and American Games, and that was. So the problem is this, you got to notify all the potentially affected athletes, which were over 200. So the USMCA ombuds contacted, as many as you could get, and it involved an issue where USA Track and Field changed the qualification standards, and it was during COVID, and they basically were allowing the competition results from the prior year to determine the team. But there were athletes who were in the military, so there are, and they didn't get notice of it, so they challenged it. So the hearing ended up starting a little bit later. We didn't have, I don't know, we did not know how many people had gotten notice or whatever. And both sides were heard. We finished at 8:53. So I had 7 minutes to send an email operative award to the USOPC.
Democratic process.
And I granted their appeal.
It's very slow.
And then what happened is within an hour, questions started coming from Athletes Counsel and them. through AAA is they said, how broad is your award? Who does it impact? And I said, well, everyone who got noticed.
You know,
I said, but
makes it
I don't
easier to
know
get
who
stuff
got
done.
noticed.
You can just repeat your
I said, I know there was 30-some phone lines, but I can't say. And I said, my jurisdiction ended once I issued that operative award. And they really were very much, well, we were just kind of like to know. And I just said, I can't decide it. I said, but well, they had to do another arbitration on the scope because, and you know, I knew the Athletes Council, and they were. I talked to him. They were like, why didn't you just tell us? I said, because and I said, I do not know who got notice. I said the parties are about the athletes who got noticed, whether they participated or not, but there was 200 potentially, and no one could answer that. Casey Wallace and her staff were calling around, emailing, and she was like, well, I can say who we sent it out to. So they did it again with another arbitrator on the scope of it within 3 days, and he came to the same conclusion I did. But if he would have, it would have been, you know, really kind of dicey if he would have done it. But it's like, you know, we literally had about 2.5 hours of hearing, and then I finally had to say, and both sides said, okay, we pretty much said what we had to say. But of course, lawyers always would like to say more. And it's like, you know, this deadline is hard and fast. So PC General Counsel sending emails to everyone reminding them, we need to know by 9 o'clock, because by within 10 minutes later, we type in the name and we must send our email. If it didn't get to the Pan American authority, they said the U.S. team would be screwed because they don't. What's that? Well, it's like they say that the show must go on. They're not going to stop the competition for it. And I did some of the admin in social and you know, did a couple of all-nighters. That's what you do. You know, we had one hearing that started at 1 in the morning associated because the parties involved, they were up in the mountains, 40 kilometers away. Once that competition ended, we started at 1 in the morning, and we had the hearing and a 20-page written award by 11:30 a.m. Three-person panel, and we moved it along because we had to do it. It was the final day of competition. It was a very interesting case. Unfortunately, we couldn't resolve the merits because it was out of time. But yeah.
So you had to be on site for a certain hearing.
So they'll have on-site. That's why I had asked them. I don't think but what they do is they'll have a panel of cast arbitrators. And like, I don't know, it could be an eligibility issue or someone gets tossed and they want to raise it and they need it like very quick. So they'll do it online. And then you can do what's known as an operative award, which is just bottom line. And you have to provide a Swiss law is
charming that you would think that they would even be filing commercial. Yes, of course, how silly.
But you gotta be sure that
The
that's
question is
gonna
how
get,
many
you're not
things
gonna
they
change
have.
the reason. But if, with the 7 minutes, I just had to say, I'm really in favor. I think I put a 1 sentence. I said, you know, there was not an appropriate notice change, because usually it's whatever's published, that governs. But, and then they sent something out, and then these service members, they said, we're in Germany, they never got it. And they were like going, we shouldn't be bound by 100 times from here, tell me. And I said, you're so busy here, track and field, trying to get around. It's Norm Williams. So I saw him, he goes, I felt like punching him. He goes, but I won't. And I said, Norm, I said, you know what? He goes, well, we weren't able to field our best team because of you. I said, no, not because of me. I said, because you guys needed to make sure if you were going to do it, you got it. He's like, well, you know they were on this thing. I said, well, I tell you, it's not.
there was a major
That's the right decision, whether you like it or not.
saying
So you always have to
the NCAA argument
willing
that
to.
yeah,
Yeah, it might be. You just do it and you just say, you know what? I think it's better. And there's never gonna be everyone happy. But they got a full and fair opportunity word, and I'm gonna quickly start ordering my lift while I'm quickly.
Oh, yes. No, is it like, we're constantly getting,
it's just like
or is it really spread out, or?
It depends. There's a lot of things, the court sets up 10 days beforehand. You get a lot of eligibility issues, nationality
sports is
disputes.
gonna be here forever.
You've got athletes who didn't think they got a fair shot to make their country's team. It's resolved by domestic arbitration in the U.S. But a lot of countries don't. So you get a lot of, as the games go on, it's more the competition.
That's all we can hope for from our kids, right? Please take care.
But you can take elections passed, go to games, but you have to, you're like a, to me, if they contact you, it's like,
Stop everything.
you got a little bit of time, but you're pretty much working around the clock, and it's kind of an adrenaline rush. I've been lucky. I got to do it 3 times. But most people don't even get
Exactly.
So I don't think I will be getting, really any more. But, you really have there's a.
Good luck in the shower.
12 minutes.
Maybe I don't clock out until the minute.
Oh, wow.
That's why I learned to do the tour is going to take some extra time. Because
Oh, yeah.
But Karen, I wanted to ask you, in addition to CAS, I'm on most of the US. So it used to be AAA would do what's known as the Section 9. But now it's under New Era, which is just an online. And they're looking for people who would have to add to their arbitral roles because they picked up some sexual harassment. I had told him kind of created this platform, and I've been doing the Section 9s, and I'd send them emails. Yeah, I've done this over the years, and I had recommended our Osborne and talked to Gengaro. Would you be interested? I could give them your name, and
No, absolutely.
they're looking for people who've got the expertise. I'm a little biased, but I think law professors are well suited because we got the independence.
Right.
And sometimes it's like someone, if you, not that they can be very much impartial, but there's a difference. And you need people who actually taking a broad look at these sorts of issues. So I will pass on your name and Dionne's, and then I'm sure you'll probably hear from him because I just was emailing him this week and he was looking and I said, well, I got one person and I was thinking because thinks it's perfect.
I'm not a Title IX expert, but I'm happy
But
to
at least
brush up on it.
well, you know what it is. I mean, but there's a lot of people who don't. And just because it's commercial or consumer arbitration, it's a very different thing. And of course, you got to rely on the parties to present the case. But the point I made is usually the counsel for the governing bodies, they're experienced, they know arguments to make. And sometimes you're like, oh, you really are doing this. Or you don't, some people say, don't say anything. But I'll just say, to be clear, are you already not asserting this claim? And and there's times where you're not saying the case, they just say that. Things can present their case. But here's this case, like both sides, to come. and just leave it at that. And that's kind of, that's what happened in some of these cases. And like a few of these cases, they did not raise. They went the parallel thing, and I talked to the arbitration panel, and they're like, well, you can't do something that, but I think now it's almost you might have to say, there's not here. And given, these recent statements by the European Court of Justice, is this an issue? And you sometimes get it's intentional, strategic. They don't want to raise it. They want to see how the arbitration comes out, and then they can come in after the fact. But it's like, I don't think you can. It's like, if you want to bring a parallel proceeding, yes, I think you almost have to assert because you can't come back and say, we just presented this issue to the arbitration panel. You can't do it before but yeah, you do get a little bit of strategic things. In the safe sport, what comes up sometimes and then you're like, well, wait a minute, and then you'll get the accused who will say, I really can't say anything because we're pending court. And you run into these catch-22s, and you're like, all you do is resolve based on what's presented. You can draw an adverse influence if someone refuses, but those can be real. It's not easy, and it's as much evidentiary you're protecting. And then you get the issue, sometimes they'll say, look, this was a very traumatic experience, as you might imagine. And then you've got counsel says, I want to cross-examine. It's like, wait a minute, you might have to submit your questions to the arbitration panel and do it that way. And you're really juggling fairness, right to be heard. Those are very tough. You can go to court and on very limited grounds try to convince the court to vacate on the grounds that both parties were not treated fairly in presenting their case. Usually a court's not going to review the merits because the rule is like there's a federal law for safe sport cases involving Olympic sports that goes to arbitration. And because Congress has said arbitration, so courts, it's a very, very limited judicial review. It's important for the arbitrators to get it right, just to maintain the integrity of the process. But it's harder as a losing party to convince a court to vacate an arbitration award than to convince an appellate court to reverse a trial. So that's why when you get chosen as an arbitrator part of the panel, very rigorous and you have an obligation to address all the claims and defenses both sides assert. So you're effectively bringing award for the perspective of the losing party to basically say, look, I heard you, but here's why I do not accept. That's about all that we can do. I'm lucky I've not had any judicial challenges. I did do one. U.S. Soccer Federation has an internal arbitration procedure. And there was a local entity that had applied for membership in the state association, and they were excluded. And they presented their case. It was kind of an agreement among the other clubs. They didn't want to, a little this, a little of that. Then under Soccer Federation rules, they could appeal the arbitration decision, which they did, to the U.S. Soccer Federation Board of Directors. And I was general counsel and stuff. But it was like, but yeah, the general counsel for the state thing was cocksure they were gonna win. And I was sitting there. The council is going to raise antitrust concerns, but you're really arguing that it's an arbitrary or capricious decision. Not to further what's in the State Soccer Federation, but to further the best interest of the local entities that don't. And the interesting thing was, did it with, a lawyer that was me, an athlete, a soccer fan. And I had someone who was a Harvard graduate, was going to go to law school, and was an MLS soccer team. So he wasn't able to see a game when we did the hearing, but he read the transcript, we talked about it, he was very much on board, he's so it was really kind of fun. So we're going through that. I don't go to law school, but he was really good. He was, it was an interesting case, but yeah, it went to the GC said, well, we weren't really worried about it. There were a couple, not so much your decision, but just how the scope.
Interesting.
Yeah. Well, I gotta run. I guess they're coming in a couple minutes. Nice meeting you too. Yeah, thanks again.
Thank you so much, Matt.
Enjoyed it.
We're gonna get started in about 5 minutes. So I will see you on the other side.
I don't agree with friends for destination. Italy, random city, we go. Food is good, people are nice, weather is nice.
En el aeropuerto no puede.
How are you?
I'm good. In here in the yes.
Todos los casinos, todo. Los taxis suben más.
Oh, I see.
Si quieres pedir una fea, tienes que pagar.
Cheryl? I don't see it. Oh, here it is. I enjoyed making this happen.
Yeah, well, you did the heavy lifting. So I can't stay for the end.
Oh, yes, but safe travels
Yes,
back.
thank you.
I hope to see you again.
Yes, take care. Okay, bye.
you.
Bye. Take care.
See you soon, Matt.
Yep. Send me your slides or whatever you're presenting on.
Oh, thank you. Sorry. How do I get my?
Oh, yeah, we'll pull it up in just a second.
Shot. What am I doing here?
Con mi pan mordido. Como rata.
Oh, I'll get my honey.
¿Cuántos comes?
Thank you so much for hosting us. So
So we'll say goodbye after one.
Okay, all right.
Quitas el mono. Cuando la gente se droga y no tiene drogas, el mono, tienes el mono.
Arbitration is really meant for voluntary but I think in sports it's such a particular way of arbitration, more like just deciding and not being like evenly
que soy embajada, pero por salud. Estoy mordiendo.
One party that has way more power than the other one, and that's just posing this arbitration to the other party. So it feels more like a disciplinary or tribunal than it really is arbitration. So I think most of the time we see it like this is just an appeal in disciplinary law instead of arbitration. And that's why we impose these safeguards.
Yes, I love it. Now I want more
disciplinary law rather than
This is my office bag. We have two
Yeah, we can just ignore
Porque hoy
yeah.
traje los de
Yeah,
tapatío.
in my PhD, I did research on disciplinary law most of the time. So are really transposed into this arbitration panels because we don't see it as arbitration. Yeah. Because it's not voluntary. Yeah.
No,
Yeah.
we don't do it. We can do everything by choice.
Pero yo creo que tú tuvieras las tantas.
No, esas son mis cosas. Yo me las compro.
I put it on a 2-hour flight. Yeah, but you can probably do it anyway. Yeah.
Sí,
Not the biggest thing as you think about it.
But that'll vary from you.
You have people that
Like, what you doing? Like, what you get? What you just
Pura lo tendré cuando tenga restaurantes.
Ya un par de meses.
Exactamente, nomás porque ya nadie te cree.
La humildad ya pasó.
Amsterdam,
Es que es muy malo conocerse.
but it was cheap to hop on a train to Amsterdam and
Me pongo vaqueros y zapatillas para disimular, para integrar by the IOC.
Para todos los mandos jodidos.
So we kind of think like there's
Ya me di cuenta que
ahora
después
entiendo power of something. Yo digo, no,
no, ya ves, entramos por gusto.
at least see the imbalance.
Por ende, en España puede ser discriminado.
yeah, thank you. I'm focusing on this couple
Por feo, ¿no?
through a labor law.
En España
Writing and saying it's good for labor law.
Yeah,
So I'm working into
nos sentimos mal, entonces tendrías con un grupo para que nos parezca súper
and then I'd
Sería
like to
como
transfer
Dios
it into
nos deja ahí.
en la universidad.
But look at
Yo me dejó estuve traumatizada un año, mira la risa, claro, porque me llamaban pecho palo. Y te has dicho pecho palo. Yo
That's what the European governments
I think they should be rolled together.
like.
I guess they would.
Yo dije, vamos a mirar en el interior. El interior era peor que el exterior y no me dejó de no poder trabajar. Digo, me dejó porque se estaba liando con los
Has the power as well as the power.
la comisión. Entonces le da unas ínfulas
You might have to, yeah, you might want to need to make a phone call. And so I was trying to figure it out.
Yeah, and we were talking about it.
pues no, porque llevo Tuve que fue segundo de carrera, imagínate que la vaya a borrar.
How is this the biggest problem in such a global American talk about piracy? It's about human rights.
Yeah, and I'm so the ones that I'm really, Exactly. Yes, absolutely. For my
Era la 1:30. A la 1:30 era cuando empezaba, que siempre se me olvidaba antes de media hora.
Igual con el inglés, pero ya estoy en nacional. Yo sí que hablo inglés. Yo sí que no hablo inglés.
Okay, everyone, we're going to go ahead and get started again. Okay, so we're going to go ahead and get started. Oh, I guess I should turn the music off. Huh? There was something I was supposed to do. Here we go. This mouse is not cooperating with me. Okay, so we're gonna go ahead and get started. So welcome to our final panel of the symposium, Technology, Media, and Cybersecurity and Infrastructure. So mega sporting events today operate within an increasingly complex technological and digital ecosystem. The modern World Cup is not only played in stadiums, it is experienced through global broadcasting networks, digital platforms, data systems, and social media environments, and connect billions of viewers around the world. With that expansion comes new legal and governance challenges, including cybersecurity risks to major event infrastructure, data protection and digital surveillance, the influence of media narratives and reputational governance, and the financial and procurement decisions associated with building and maintaining the infrastructure that supports these events. The 2026 World Cup, involving multiple host cities across 3 countries, makes coordination across technological systems and infrastructure planning especially complex. So our speakers this afternoon will explore these issues from several perspectives, examining technology and intelligence cooperation, legal frameworks surrounding media and the economic and procurement realities of large-scale infrastructure development. So together, these presentations will help us to better understand how technology, information systems, and physical infrastructure shape both the operation and legacy of the World Cup. So we will have 3 speakers in this session. The first one will be Dionne Koller. So she's going first. Then we will hear from Guillermo Mendoza. And finally, we will hear from one of our students here at the University of Houston Law Center, James Gengaro. And his presentation will actually be digital. Okay, so Dionne, thank you. Okay. Should be all set. You can use the clicker or the, yep. And that's the, right, and if you move from the mic, then.
Okay. Got it. All right. Thank you very much. Thank you all for staying. I know it's hard on a Saturday, but I really appreciate you being here. Thank you, Karen and University of Houston for spearheading this conference. This has just been fantastic, and I have notes all over the place from stuff I have learned, and so I really appreciate being a part of this. I'm going to apologize in advance. I have a flight to catch back to the East Coast, so I may not be able to stay until the very end of the program, but it is no comment on my enthusiasm for what we are talking about here today. So my goal is to give you an overview of my argument, hope to foreshadow for you where I see this work going in the future. And I, of course, look forward to any of your questions and feedback that you can give me, as this is still a work in progress. So I think everybody is aware that sport is used by nations across the world as a nation branding or a diplomacy tool. Commentators in academia and popular media, policymakers have focused for the last few years on a particular use of sport, how countries like China and Russia, Saudi Arabia, and others, and using sport as an instrument for their own political ends or their geopolitical gain. And we frequently call these attempts, or we label them, sports washing. Have any of you heard the term sports washing? Probably everybody has, right, at this point. So as I'm going to explain, I assume that the term sports washing is more than just a media label or something that policymakers throw around. Scholars and other commentators are actively debating sports washing and all what it means. And I'm not attempting with this work to kind of enter those discussions about whether sports washing describes something new or something that's been going on for a very, very long time, or discussions about whether the United States, for instance, in hosting the FIFA World Cup, is engaged in sports washing. What I'm trying to do and what I'm trying to understand with this work is what role the law plays in a sports washing transaction. And what I mean by sports washing transaction is, say, when China hosts the Olympic Games, what role does law play in making that arguably sports washing? So the goal for this work is to provide kind of a theoretical framework for thinking about the law's role in sports washing. And then in future work, I hope to provide examples in US law where I believe the phenomenon I identify here exists. So what I start off with in the piece is I talk about, well, what is the sports washing discourse? What do we think sports washing is? And so before I get into my argument, I think it's useful to start at this place where we think we all know something about sports washing. We've certainly heard about it. But sports washing is a relatively new term. So scholars believe it was first used in 2015. In 2023, Congress actually held hearings on the Live Golf deal between the PGA Tour and Saudi Arabia. And Senator Richard Blumenthal and Ron Johnson said, this hearing is about sports washing. So sports washing, of course, is a term derives from the terms whitewashing, greenwashing, pinkwashing. There's some slightly different meanings with this washing label. Of course, whitewashing refers to the kind of historical revisionism that seeks to sort of downplay or cover up the harms of slavery, overlook the experiences of Black people and other marginalized groups. Pinkwashing and greenwashing, slightly different. They're often used by corporations to kind of exaggerate their virtuousness, associating themselves with a cause that will give their products a halo. So whatever it is, we are familiar with this washing term. And like those terms, sports washing is used pejoratively. It is not a compliment to say you're involved in any kind of washing. And the term is also the way we frequently use it in our discourse today. It's primarily aimed at non-Western regimes using sport to gain international legitimacy or distract from human rights abuses and other harms. So I looked at, beyond the kind of discourse, what we think it is, what we hear about it. There are actual definitions or attempted definitions of sports washing. So outside of the law, scholars have been debating whether sports washing is its own distinct phenomenon, whether certain examples qualify. And I want to be clear that I adopt the view of scholars who assert that sports washing is actually a term with its own independent analytical value, that it is something specific. It is something a little bit new, though it relates to uses of sport that we've had as time immemorial. There is not, though, a legal definition of sports washing, but scholars outside of law have attempted to define the term. Most of the scholarship in this regard has come from sociology, international relations, sports management, and the definitions range from broad to pretty narrow. So one scholar has defined sports washing as a phenomenon whereby political leaders use sport to appear important or legitimate on the world stage while stoking nationalism and deflecting attention on the home front. Another definition of sports washing is using sports to launder a nation's international image that has been tarnished due to human rights violations. Some scholars have simply said that sports washing is reputational refurbishment for nations. And scholars like Jules Boykoff have argued that sports washing can actually be used as a tool by ostensibly democratic regimes like the United States, again, giving the FIFA World Cup as an example of this. Some scholars have, in trying to drill down into what sports washing is and what that term may offer us in terms of analytical value, some scholars have kind of drilled down and taken a philosophical approach. And they have emphasized sports washing's moral dimensions, breaking it down into two distinct harms or wrongs. First of all, these scholars argue that sports washing exploits valuable elements of sport, that sport is valuable in and of itself, and that it also acts to create these sort of valuable relationships, say in a community. Public enthusiasm for sporting events is an example of that. Community identities built around being a sports fan. I loved walking around this campus and seeing red and UH and sports stuff everywhere, right? We think of those elements as very valuable, and that sports washing sort of appropriates some of this to accomplish its work. It's taking something important and or important to many people, and it's polluting it with problematic politics or other injustices. A second claim to sports washing's moral dimensions is that it makes sports participants, or those of us who participate in kind of the sporting equation, complicit in the wrongdoing. It makes athletes and fans complicit in the injustices that sports washing is said to cover up. So supporting a major sporting event taking place in a country with a terrible human rights record makes all of us complicit. And so scholars say this is another part of the moral dimension of the harm caused by sports washing. But ultimately, some scholars have argued that sports washing is a really complex phenomenon, that it is part of the workings of global capitalism. It has multiple dimensions. It has multiple actors. And while there's not one agreed upon yet definition of sports washing, one scholar has said at a minimum, the term is stimulating really important conversations about the entwinement of sports with government and politics. And that these conversations, it has been argued, should be undertaken with a level of nuance. That we should view sports washing beyond these usual kind of one-dimensional ways in which we're using the label, or China's engaged in sports washing, or Saudi Arabia is engaged in sports washing. And so I am taking up the suggestion in the piece that I submitted for this symposium that sports washing is indeed a complex phenomenon, and I am looking for ways that the law might fit into that beyond what has been discussed currently. So my argument, importantly, does not rely on a particular fixed definition of sports washing or any particular consensus on what does or doesn't qualify as sports washing. And the reason is that however we define sports washing and whatever we sort of think about its analytical value, I argue that sports washing relies on a sports product that is virtuous or at least has a pretty sturdy claim to being virtuous. And so my argument is focusing on what is the law's role in that, in producing a sports product that can claim virtuousness. So I want to also fill you in, again, before I tell you what my claim is on why I'm doing this, why am I interested in this project, and I think it's useful to understand what my argument is. I want to situate this work for you in current legal scholarship and explain to you what I hope to achieve from it. So the existing scholarship has really not explicitly addressed the ways that law may play a key role in sports washing. And so my goal is, as I said at the outset, to argue or articulate a framework that defines the roles that law will play. And so my claim is threefold. First of all, I argue that law does play a role in sports washing beyond what we can currently assume it to be. Number two, law supplies an important ingredient in sports washing by, as I say, moderating the tensions between what sports purports to be and what sport, as operated by the modern sports industry, very often is. And number three, that by endorsing the power of sports sponsors and ensuring a supply of talented athletes, the law helps create the value that sports washers can appropriate. And so ultimately with this framework, I believe that we can identify ways that United States law, as applied to sports, may be part of a larger kind of global sports washing project. All right, so I start off by explaining what our current assumptions are in terms of the law's role in sports washing. And again, while there is not really an extensive amount of legal scholarship on sports washing, what there is includes a few usually unstated assumptions about the law's role. And the most significant of these assumptions is that there is actually a sports product with the ability to mask or distract or normalize these morally objectionable actions of a regime. So in most sports washing accounts then, sport itself is assumed to be valuable, or at least it's assumed to be morally superior to the actor seeking to do the washing, so to speak. And from this, I argue that we currently assume then two roles for law in sports washing. First is that the law plays a role in what I have labeled the benign background, right? Law is part of the commercial transactions that accompany modern sport, and I think that interview, that fantastic interview, thank you for recording that, with the general counsel of the FIFA World Cup is exactly what I'm talking about. That's the benign background, right? Is Coca-Cola a sponsor? We need contracts here. We need employment agreements. I call that the benign background. So law is involved in sports washing in the sense that if the FIFA World Cup is happening in China, in a Saudi Arabia, in a Qatar, there's going to be contracts that make that happen. The second assumption we make about law's role in sports washing is that it plays what I have called a corrective role. Our law is always envisioned in these stories as a potential remedy for sports washing. Law is the hero. Law has a halo, right? Law can swoop in and save the day. If we're all worried about sports washing, law is going to get us out of it. So I introduce then a third role for law in sports washing, which is that sports washing can supply actually a very necessary ingredient in the sports washing transaction. So my paper can sort of moves from what I consider to be the usual, often unstated assumptions about the law's role to what I consider to be a third, and I say completely unexplored role, which is law serving to wash sports. And specifically, I argue that the law plays a role in ensuring a valuable sports product for the modern sports industry. And this product is what can do the masking or the legitimizing that sports washing claims that we assume sports washing can do. And it does this by playing an important role in moderating or resolving tensions that could threaten the sports status quo. And I think earlier presentations really highlighted what some of these tensions could be with respect to, for instance, human rights. So as we all know, there are widespread claims about the inherent goodness of sports. This is so obvious. We've all grown up on this. This is worldwide, right? In the US, sport is frequently said to be an answer for many societal problems. And in fact, you can trace this through the arc of history, right? Sports was going to save us from our worries about the Cold War. Sport is going to be a way to save children who need saving, children from disadvantaged socioeconomic backgrounds. Sport is going to save us from a childhood obesity epidemic, right? Sport is always going to rescue us from something. But these claims about the value of sport bump up against some really troubling empirical realities, especially for athletes and for many others impacted by sports. And I think Karen's presentation earlier today talked about a lot of those impacts. And so many scholars have explained that there are various legitimacy issues in sports today, ranging from corruption and human rights abuses to lack of meaningful representation and a voice for athletes and unfair governance structures. And these are tensions or issues that could actually threaten the sports industry, I argue, or the sports, what I call the sports status quo. So I argue that the law resolves these tensions or problems by supporting our well-known sports sponsors. So law supports the sports industry and therefore, I argue, supplies a necessary ingredient for sports washing in two ways. First of all, law serves to endorse the power of sports sponsors today. And second, it acts to ensure a supply of talented athletes upon which the games rely, right? You can't have sports washing unless you have an Olympic Games or Paralympic Games or a FIFA World Cup that features the very best athletes in the world. Okay, so I talk about how the law endorses the power of sports sponsors. And I mentioned things like the fact that sports seems to have a special status in international law. James Nafziger has talked a lot about this. The UN endorses the value of the Olympic and Paralympic Games, right? The law permits sports sponsors to operate through this practice of globality, monopoly, autonomy, everything we've been talking about here, this notion of sports exceptionalism that was highlighted previously. There's very little regulation, right? And the law allows sport to operate with a sense of legitimacy through this theory of consent. Well, everybody's just agreeing through contracts, right? And to let this theory of consent sort of fuel its autonomous operation. So law is relying on this, supplying all of this sort of legitimacy to the system of global sports, and of course, helping to supply a sense of legitimacy to the global sports legal system, again, which we have heard about previously, like CAS and this notion of lex sportiva. In addition, the law helps ensure a supply of talented athletes upon which all these games rely. First of all, by permitting sports sponsors to operate with autonomy and monopoly power, athletes are left with little choice but to accept the terms or don't participate at all. In addition, it is, of course, a law and policy choice to not create any kind of countervailing power source for athletes and for those impacted by the operation of the modern sports industry, sort of letting them operate with a take it or leave it, or this is the way it's going to be kind of posture. And so ultimately, I argue that the law confers power and legitimacy on sports sponsors that can then be appropriated by sports washing regimes. And I think that this provides a new way of thinking about the connection of law to sports washing beyond these kind of current assumptions as it's the benign background or it's going to be the hero of the day. And I hope that my future work will focus on examples of the theory that I lay out here. So just a few concluding thoughts in case any of you are alarmed by what I'm saying, which is like, is she equating US law or modern legal systems with a sports washing regime? And the answer is no. This account of the law's role in sports washing is not meant to do that at all. I'm not equating Western legal systems with human rights abusing regimes. The intent, though, is to generate, as current sports washing scholars have said, to generate kind of general greater awareness of what is happening in sports washing and the ways that the law may help actually propel the power that sports washing has. And it's my hope that if we have greater awareness of the ways that law intersects with sports washing, we can generate additional solutions beyond simply hoping that law will swoop in and save the day. And so it's my hope that in future work, I can give specific examples of the law washing sport, so to speak. We have plenty of them here in the United States. But for now, I thank you and I look forward to your questions.
So you mentioned law washing laws in the US.
Mm-hmm.
So how is that implemented?
So I'll give you an
Conflict of interest?
Yeah, so I'll give you an example where law legitimizes. So I think an example is youth sport concussion statutes. So the NFL, the NCAA had a very serious issue about 20 years ago, 25 years ago in the US with the concussion crisis in sports. Yes. And so the NCAA and the NFL lobbied all states now have youth sport concussion statutes that say, if a child is suspected of suffering a concussion, they must be removed from play and can't come back until cleared by a doctor. That's terrific, right? It certainly gives the appearance that we've made the games safer. But public health scholars have studied that, and we haven't made it safer at all. The laws are unenforceable. They most frequently confer immunities on sports sponsors. And so this is an area where I would argue we have now washed sort of youth sports where head injuries can happen by making it appear that these games are safer than they are, for instance. Other examples, the amateurism defense in intercollegiate sports and saying there's something special about intercollegiate sports and the law sort of giving an imprimatur of legitimacy for a very long time to the system of intercollegiate sports, which in the Alston case, the Supreme Court said 9-0, it's really just an antitrust violation, right? So I think there's a lot of specific examples where law has endorsed sports systems, where law could have come out a different way. But by endorsing those sports systems, it does what I argue it does here, which is it gives it a sense of legitimacy with the public, and it also leaves athletes with very little choice. Yeah.
How effective would sanctions be for curbing the power of sports washing?
So I think that would be really hard to do. First of all, I think what Karen talked about today is where's the governance? Who's going to sanction a sports washer, right? Now, we've talked about in the United States, can we use certain statutes to prohibit sports washing from happening? But I don't know how effective that would be because we can't even decide on a definition for sports washing. So for instance, if we're going to use US law to sanction or prohibit sports washing, we have a decent body of literature that says the United States is engaged in sports washing by hosting the World Cup or the Olympics, right? So when you want to create a regime of sanctions, I think it would be important to have some stable definitions of what the activity is. And then you would have to ask, where are these sanctions coming from? And so I think actually the totality of this conference proves how difficult something like that could be. Yeah.
Apologies for coming in late here.
Thank you for coming.
You may have talked about this already, but I think you just mentioned it to Leon a couple seconds ago about the importance of at least the utilization of antitrust here. And I guess kind of building on that, Because you're kind of seeing it both in the pro and the college side, definitely most recently in college, obviously with the NIL cases where antitrust now has become a significant, and historically antitrust was always kind of that weapon that the players could use as well. Is that, you know, and I guess maybe speaking both the United States and internationally, but is that really the potential greater sword for addressing it? Or?
Yeah, so I don't think antitrust law is the sword to address sports washing, but I think it is the application of antitrust law and how, if you look historically at how courts in the United States sort of distorted antitrust law in order to come up with a solution that protected, say, college sports. That's an example to me of law washing sports, where you know you have these sort of tortured reasoning. So I don't think so. I think we obviously have a different day now. But the other thing about it is, and I think your question is a fantastic one, and I should address this in my future work, which is we have handed sports sponsors monopolies. And so, for instance, you can't use antitrust law to address, say, what's going on in the Olympic and Paralympic movement in the United States because you have the Ted Stevens Act, right? So where we have ceded so much monopoly power to our sports sponsors, there actually isn't that unique situation that existed in college sports. So I don't think we could even use it if we wanted to. Thank you.
Thank you.
Okay. Thank you.
Thank you.
You're good.
And I'm gonna stay for a few minutes.
Okay. Guillermo. This is always fun. Do you see your?
González Mendoza.
Ah, here it is. Okay, let me show from beginning. Take it away. Oh, and you, so the here or and if you move.
Okay.
Okay.
Morning, everyone. My name is Guillermo Mendoza. I am partner of Stratia, a Mexican consulting firm specialized in risk advisory and corporate intelligence. We prepared for this occasion a paper around the possibilities to construct a North American intelligence mechanism. First of all, a disclaimer: if you are expecting to hear about spies, cover operation, or James Bond, or things like that, this is not the case. I regret to say that intelligence have more to do with information than with ground operations. And this paper is more about dollars, customs, and trust. So also I want to recognize my co-authors, Puerto González and Mario Sanchez, that I'm for sure that I'm sure that they can answer any question you have after I finish try to explain the paper. So let's go to the point. Where we are right now, there is a global trend about the transformation of national security concept from a traditional paradigm centered in things like terrorism, military threats, and transnational organized crimes to a new economic security paradigm that implies the weaponization of things like global supply chains, foreign direct investments, and critical technology transfers. Why we are present this paper in this occasion? As we heard yesterday, Brian mentioned the goodwill around an event like the World Cup, but the reality is at this moment the trilateral relations are very, very tense. And it worth remember that the bid for the next World Cup was present in 2014 when Peña Nieto was president of Mexico, Obama was president of the United States, and Trudeau was prime minister of Canada. But more important, when the idea of North America and its integration was not in question. So This new reality, or the weaponization of economic and trade spheres, put us on a new challenge about how we can attend specific demands to preserve the economic integration of the region. So the reality is that we are living in an era of geopolitical rearrangement, and the traditional paradigm on security, as I said, centered in terrorism, is now being balanced or often outweighed by a new economic security paradigm. The commercial exchange and capital flows have been weaponized, and issues like global supply chains for direct investment, screening, and critical technology transfer are now central vectors of national security. The reality is also that no state, not even global powers as the United States, can manage this complexity alone. And this complexity demands mechanisms of intelligence interchange. That's our proposal is put. So how we can construct new mechanism of intelligence for regional demands around trade and investment? Well, from the theoretical perspective, we part from a classical theory in security studies and international relations, that is the construction of security communities, but more specifically around the pluralistic security communities. This theory is based in three basic assumptions. First of all, a diffuse reciprocity, which implies that the partners of the agreement banned the use of violent means to resolve its difference. I think that, with exception of some declaration from President Trump, this is an assumption that we can take for sure. The second pillar of this conception is that the construction about a we feeling or shared identity around a region. At this point, it is worth to remember that Alberto yesterday mentioned that soccer is a trigger for the way citizens in the three countries observe the region as a whole. And Santiago questioned if a mega sporting event can foster cooperation in a moment of regional tension. So the celebration of the World Cup can trigger new opportunities in this pillar for the conception of the regional identity. And finally, the third pillar for this theoretical conception is the existence of bench transaction. That probably this is the only pillar that is really strong at this point, and is granted by the existence and the application of the USMCA. So, in this point, we think that, we part from this theoretical point because if we construct a pluralistic security community to interchange intelligence, member states retain their legal independence. The integration is achieved through institutionalized risk management and shared intelligence, and the mitigation is less structural at this point. So there is another important point in our evaluation, that is the paradox that exists in the North America region. In one hand, we have a high economic integration, but a very low risk management that is shared. So, give me a minute. This paradox creates structural tensions. Without shared economic intelligence, our deep interdependence can actually breed mutual distrust rather than collaboration, especially when we face external rivals. So, how can we attend, or how is more evident this paradox? Well, when we take a look at the regulatory asymmetries that are around the mechanism that every country in the region has individually to attend the new investment flows. So The most robust mechanism that is in place right now is the Council for Foreign Investment in the US, that it has a clear and explicit mandate around national security and implies a robust bureaucratic power to review these new arrivals. In the medium term is the Canadian mechanism that is based in the Investment Canada Act, and it balances the concerns about economic benefit and the security concerns. And finally, Mexico has a very weak mechanism to review this new investment in the country. The Ley de Inversión Extranjera, or law of foreign investment, in reality have an economic development goal, not a security review process in place. This is really a problem because at least the half of the new investment that arrived to Mexico are not evaluating in the through a process that attend some problems around who are behind this new flux of investment. So this conduct us to very problem for the Mexican perspectives around the preservation of the USMCA. Because of this lack of security mandate, Mexico is perceived as the weak link in the regional chain. Mexican current law successfully channels capital because if you release the records, Mexico has historic levels of attraction of foreign investment, around $41 billion each year, but it ignores geopolitical risks. This absence invites third-party rivals or trade triangulation schemes that have filtered through Mexico to reach the US and Canadian markets. This isn't just a Mexican problem. It erodes trust across the entire commercial region bloc and triggers unilateral coercion from our partners, like threats for tariffs that we hear every morning. So, to attend this, we are really in a crossing point. I don't going to stop very long at this point because Professor Julian explained yesterday the process to the USMCA review. But what is not in question is that in the path ahead, there is a fork for the possibilities to maintain the commercial integration in the region. So we can elect at this point about two paths or two probable paths. The first one is that the three countries elect to escalate in the friction and pursue unilateral pressure regarding some specific problems like the Chinese influence or the absence in Mexican regulatory framework to screening new investments. Or the other possibility is to pursue the idea of Fortress North America, that is an idea that has been profoundly discussed during the public consultation that the three countries have convened individually. So the reality is that with a clear without a clear procedural ways in enforce it, there are a really important possibility that political pressure over foreign direct investment and Chinese non-market influence will drive the outcome of the review. So, to analyze the possibilities, and this is our specific proposal in this concern, there is the construction of the North American intelligence community based on trade and investment. So to analyze the possibilities or to construct some scenarios, we apply some foreign techniques. And we analyze a variety of variables. And we found that these two are the most important in this context. The first one is the position of Mexican institutional will to transform its internal capacities that go from a reactive adaptation to a proactive transformation. And the other main driver is the degree of trilateral cooperation that go from a totally fragmented position in the three countries to a totally integrated will to conform the new mechanism. So, derivative of this, we present four scenarios. A regional architect, a reluctant partner, a proactive island, and a structural vulnerability. Remember that these scenarios analyze the possibilities and the benefits that Mexico can achieve through the construction of the regional intelligence interchange mechanism, not the benefits for the three countries as a whole. So these scenarios, and this is a second disclaimer, are not predictions. They are decision-making tools to evaluate the consequence of action versus inaction during the 2026 process of review. So the first scenario that is named the regional architect implies integrated cooperation plus a proactive position from Mexico. In this scenario, we saw a reality that implies a joint trilateral intelligence framework with bidding protocols for investment screening and supply chain monitoring. The specific Mexico's role in this scenario is one that implies co-designing over adaptation. Mexico can influence the scope and share assessment and maintains a balanced approach toward strategic competitors. The results for Mexico is high trust, regulatory harmonization, and preserved autonomy. In this scenario, Mexico is an architect, not merely a recipient of directives. The second one scenario that is named reluctant partner implies integrated cooperation, but a more reactive position from Mexico. What we can observe in this scenario, that the US and Canada dictate the economic intelligence framework, and Mexico participation is reduced to minimal compliance. So Mexico follow new or existing mechanism regarding new arrivals of foreign investment. The specific Mexico's role in this scenario implies forced adaptation without structural transformation. In this case, Mexico cannot contribute to shared threat assessment due to limited internal capabilities. And as a result, we can observe asymmetric cooperation and that Mexico suffers from marginal status, accepting for a risk perception without the data to counter or nuance the threats. The third scenario that we present in this study is named a proactive island. It implies fragmented cooperation plus a more proactive position from Mexico. In this case, the trilateralism fails during the 2026 process of review of the USMCA, and the region fragments into isolated nationalistic economic security approaches. The specific Mexico roles in this case imply that Mexico successfully modernized its own foreign direct investment screening and it have the capabilities to establish an interagency body and protecting critical sectors domestically. But the result is that capability with that framework, Mexico can evaluate transactions independently, but lacks access to partner intelligence, imply that it relied on inefficient and ad hoc bilateral fixes. This is not an ideal scenario for Mexico. And finally, the worst case scenario is the fourth one, okay, that is named structural vulnerability. This scenario implies a fragmented cooperation plus a totally reactive position from Mexico. In this scenario, we can observe that a total breakdown of shared intelligence, and the US and Canada build bilateral wars around Mexico, and our countries view purely as a strategic vulnerability. The specific role for Mexico in this scenario is complete institutional paralysis internally, and the foreign investment remains outdated, leaving massive gaps in regional security. The result for Mexico is that the interdependence is weaponized, and Mexican companies face unilateral coercion, ultimatums to restrict specific technologies, and tariffs. In this scenario, Mexico has no independent data to defend its interests. From the analysis of this scenario, we consider that the position from Mexico need to be more proactive to get better results. Sorry. And the lessons from these scenarios are clear. Waiting is not a strategy, and building domestic capability is now Mexico's best hedge. If the future is cooperative, Mexican new capabilities give it influence. In the other hand, if the future is fragmented, those same capabilities give Mexico protection. So proactive transformation guarantees resilience regardless of whether or not a regional consensus is reached. So finally, we propose a blueprint for the 2026 and beyond for a strategic recommendation to Mexico construct a more capable position. So this blueprint implies in the first step that the construction of internal institutional capabilities where Mexico established an interagency FDI screening mechanism with a clear national security mandate. So the second step implies the intelligence production, primarily in a national level, but in a second step in a regional level. And it implies also professionalize our economic intelligence to independently assess tech transfers and supply chains. And the last level implies regional leverage. It present this modernized architecture to our strategic as our strategic contribution to the 2026 review of the USMCA. So thank you for your attention.
How long do you think it will take to implement this institutional capability? I mean, what will be the plan?
Yeah, but it will not be ready for the July 2026 process.
Absolutely, but what is your vision in terms of?
Probably in from 2 to 4 years is enough to construct intelligence capabilities. So I mean the formation of personnel specialized in economic intelligence, not security intelligence.
And do you think that will require an independent agency, the creation of a new agency, or working with?
Any possibility is valid for this point. Mexico can accept a new legal framework for a mandate that is headed by the Secretaría de Economía to attend this kind of problems. Yeah.
I mean, what strikes me is that the regulatory asymmetry is not, I hadn't looked at this one, but for example, I've looked at green bonds and other things, and the regulatory asymmetry is something that is just visible throughout most of the USMCA systems. And so how could you see this translating into other areas, beyond just FDI?
One step at a time. Because we propose this specific new mechanism because this is a specific concern from derived from the USMCA review. All the other things that you mentioned are additional problems that we need to attend. But the reality is Mexico needs a more proactive position to transform its legal frameworks in many things.
But it's not just Mexico; it's all three countries. The asymmetry is that we've seen in so many areas, and even some of the areas like looking at the central banks backed cryptocurrencies. Each country they just go off on their own and they have their own regulation. And so by the time that they start thinking about something region-wide, they have 3 very distinct systems in place. And so I think it's from that first part of exploration that we're not getting to, that we're kind of building in the asymmetry on most of these areas. They should be cooperating.
Yeah.
We start because they cooperate in intelligence for the security, and maybe is an example to do in other places. And in the mark on the USMCA, maybe it's a good place to start to do it. It's not the only one, but it's the first place, but that we can do it and try to. Yes. Because I don't know, but we understand the intelligence like analysis to make up decisions. And so we think this is a good framework to start.
Yeah. But for the most part, like what you're showing, you have, by the time you try to regulate and fix the asymmetries, they're already there.
Yeah.
And so it's looking for a framework that from the seed, from the beginning, instead of waiting till we have 3 distinct things going, the 3 pillars that have already gone in different directions, to start from very, to set up something for new things from the beginning, because by the time we realize that there are asymmetries, it's already complicated to try and bring them together.
But I think it's a good place to have the, ¿cómo decir la ventaja?
Advantage.
The advantage in Mexico, because in other places they have. So maybe it's a space to do it.
Okay, good, thank you.
Thank you. Yeah.
I just have a comment. Wonderful graphics. Wonderful graphics.
Very clear.
Creative.
But visually just gives you the message.
Yeah. Very clear.
Very clear. Very clear.
So you have
No, I just
structural vulnerability one.
was in shock of what you were telling me yesterday about that you cannot resell your FIFA World Cup tickets in Mexico.
Yeah.
Which are very expensive. You can do it in the United States, but in Mexico you have some prohibition to do that. That for me is blocking property rights in very expensive tickets.
Okay, thank you.
Thank you.
Thank you.
Okay.
Gran logro.
Thank you very much. Actually, I'm going to, because I know
Thank you very much.
Okay. So we are down to our last presentation for today, before my surprise. So let me see if I can pull it up, I hope. I might have to call Cheryl. We'll see. Okay. Okay, this is a presentation by James Gengaro. He is a student here at the University of Houston.
Hi, my name is James Gengaro, and welcome to the 2026 FIFA World Cup in North America.
One second. See, almost
taster,
seamless,
the
but not
teaser.
quite.
Teaser, yeah.
Is that okay?
Let's see if I can get this to move over. There we go. And okay, yes, he is a student here at the University of Houston Law Center, and he is presenting his presentation. Unfortunately, he was not able to be here at the last minute. So about a week ago, he notified me and I said, look, if you can put it on a, if you can record it, then I'll try to play it. So here we go. I know, that's what I told
My
you.
name is James Gengaro, and welcome to the 2026 FIFA World Cup and North American Cross-Border Cooperation Symposium. That's a mouthful. I'm just going to call it the FIFA Symposium. I am a current 1L student here at the University of Houston Law Center, who also happen to be our gracious host for this event. So, thank you. I want to talk to you today about monopolies, specifically sports monopolies. You already see where this is going. I say some bad things about FIFA and how they rule over all of international soccer, and you are left with a bad taste in your mouth all summer about the upcoming World Cup. That is not my intention. It's not what I want to do. So I want to simply preface that there is so much good that comes out of both FIFA and the World Cup tournament that they host every 4 years, such as Curacao, who in November qualified for their first World Cup.
I didn't expect this because I thought Jamaica was a strong team, but we did it! Finally, we did it!
We will show everyone that we are small, but we are big at heart. We are going to show them that we are big at heart.
He's absolutely right. Curacao is a constituent country of the Kingdom of the Netherlands with a population of only 156,000, roughly the size of just the Kansas side of Kansas City. And the country will accrue at least $10.5 million for the participation in this year's tournament. So there is a load of good. But let's focus on the monopolistic side of FIFA for a minute. Why are they getting all this money? Let's discuss what a monopoly in sports is, how this is being handled, what are the ramifications of these monopolies, and why you should even care. And let's start with the monopoly basics. How is the game played? Well, the parameters began to be set in July of 1890, as this video explains.
The first federal antitrust law was passed in 1890, and two more followed in 1914.
The antitrust laws started out as being against power and making it easier for little firms to get into the market and survive, as well as to cater to consumers.
They sought to prevent companies from getting too big or engaging in unfair practices like colluding to fix prices. They also created an agency to enforce those standards.
As you may have gathered, there are three types of monopolies that these laws aim to break. The first is external competition, the second is internal structure, and the third is consumer health or public interest. Now, the framework of these three types of monopolies is important here. This is the structure in which we can identify what a monopoly is, how a monopoly was created, and the detriments of the monopoly staying intact. During the Gilded Age, John D. Rockefeller controlled over 90% of oil refining at one singular time. His company, Standard Oil, did not just control the industry, they also controlled its life support, where there were secret negotiations of rebates, meaning they paid less than their competitors to ship oil. They also had drawbacks, where essentially the railroads had to pay Standard Oil a fee for every barrel they shipped of their competitors' oil. Since Standard Oil was making money even when their competition did business, this created a structural suffocation where competition just could not survive. This is a perfect example of the first monopolistic style, external competition. The second is internal structure, which can be illustrated by the legal trick that companies would use before the establishment of antitrust laws called trusts. Essentially, shareholders in many seemingly independent companies transferred stock to a small group of trustees who would then go and run the entire industry as a unified entity, where this one group was setting locations, prices, and output. These types of trusts were seen everywhere, but famously in the steel, oil, sugar, and tobacco industries. The third style is consumer health, where the previously mentioned style of price fixing would lead to price gouging. Once the competition was bled out of the economic arena, all that was left was for the monopolistic entity to put their prices back up, since consumers had no other option if they wanted such a product as theirs. So price cutting would clear the board and ultimately lead to low consumer value, which would slowly strangle the United States economy. However, even since the passing of the Sherman Act, there are still entities today that act as monopolies and ultimately raise antitrust issues. And today, we're focusing on the sports world we all know and love by the largest companies and organizations such as the Federation International de Football Association, the National Football League, the National Basketball Association, Major League Soccer, and more. Such organizations encounter these same three monopolistic styles, which are vital because they negatively impact everyone around them. So first, let's discuss how we got here. Then it will be important to illustrate what these modern-day monopoly mammoths look like before finishing with the consequences of these actions and what to expect moving forward. FIFA was established in 1904 in Paris, and during this time, international soccer matches were greatly increasing. There became a need for a central governing body that could set unified rules and help to manage the cross-border matches that were becoming more frequent. Although the sport of soccer was initially invented in England, they did not want to lead this mission. So a group of continental European countries decided to form it themselves. And in 1930, the first World Cup was hosted in Uruguay. The initial FIFA World Cup hosted a mere 13 competing countries representing only 3 continents. The idea of a World Cup was organized by the third FIFA president, Jules Rimet, who eventually became FIFA's longest-serving president, holding the position for 33 years. Rimet's idea for a World Cup began as a small amateur tournament as a part of the 1908 Summer Olympic Games held in London. From there, this idea was put on hold during World War I, but eventually the 1930 FIFA World Cup was born, and the 4 participating European teams all traveled together with Rimet on the same ship. Rimet actually had the trophy stored in his bag during the voyage. After World War II, many of the football associations in Great Britain finally decided to take part in the 1950 World Cup. And since then, Rimet continued to attract more countries to the competition until it became competitive to enter. Rimet's efforts actually earned him a nomination for the 1956 Nobel Peace Prize. FIFA continued to grow into the behemoth that it is today, ruling over all of international soccer operations, and eventually went from an organization that encouraged and helped to smoothly operate logistical issues during international competitions to creating their own competition and gatekeeping others from occurring. Under FIFA's own statutes, no international club competition is allowed to be organized without prior approval coming from them. If this did occur, teams and athletes could risk sanctions and even outright bans from existing FIFA tournaments. This creation of barriers and obstacles needed to overcome the mere existence of competition highly disincentivizes others, especially when the amount of money that could be made in the World Cup is considered. This first style of monopoly, removing external competition, became a bigger issue, and eventually FIFA was taken to court. In 2023, the European Union's Court of Justice issued a ruling that addressed the legality of this very issue. The Court of Justice ultimately concluded that FIFA's approval regime did in fact violate the European Union's competition law. More specifically, they had violated Article 101 regarding anti-competitive agreements, as well as Article 102 pertaining to the abuse of dominant position of the Treaty on the Functioning of the European Union. The court further stated that commercial exploitation of media rights count as economic activities and therefore also must comply with the European Union's competition law. This lawsuit arose under the attempt to create a new competition called the European Super League, and this ruling didn't automatically approve this league, but what this ruling did do is invalidate FIFA's blocking of these types of leagues using anti-competitive mechanisms. These rules also restricted the European Union of the freedom to provide services due to these unjustified restrictions. And in addition to the European Soccer League case, the European Commission has also received many complaints from various leagues, as well as player unions, that allege FIFA's control over the international match calendar also constitutes abusive conduct. Those complaints argued that FIFA's decisions related to the calendar favor its own commercial competition and success without taking the other leagues into account. This creates a multitude of problems, stemming from scheduling congestion to welfare concerns, and this is exactly what is happening to Major League Soccer. The MLS normally had their season calendar flipped for most of the world's national leagues, because while soccer is the most watched and enjoyed game in most other nations, the United States viewership and revenue have soccer much lower on their so-called sports totem pole. Their schedule is flipped to avoid the prime seasons of the United States' more popular leagues, such as the NFL, NBA, NHL, and college sports, such as football and basketball. However, recently the MLS has cracked under the pressure and announced that they are flipping the calendar.
This would align MLS with the rest of the typical global soccer calendar. The league would run from either late July, early August through April with playoffs in May. There would be a break in December and January to avoid playing a lot of games in Minnesota, Toronto, and elsewhere in the winter markets at that time.
Yeah, there are MLS teams in Vancouver, Boston, Toronto, among others, who now have to play in November and February. This flipping of scheduling isn't going to just decrease TV viewership, it's going to create a string of issues. For starters, the vast majority of MLS stadiums are outdoors, in venues that were built for the MLS with the expectation that the majority of matches would be played in the late spring and summer. And what's more, to transition into this flipped schedule, the MLS will play a mini-season of just a few short months in the spring following the World Cup before beginning this new calendar of play. With each of these hurdles the MLS must maneuver to try and comply with the expectations of FIFA, the MLS may very likely entirely crumble or at the very least suffer greatly from revenue loss, scheduling conflicts for the teams who play in NFL stadiums, and practices like this shortened season idea. This is a direct example of where FIFA's discretionary power shifts the competitive balance and harms many stakeholders and leagues even while attempting to bow to their standards. Now, FIFA argues that their rules were put in place intentionally and to help regulate the sport. They argue the exact reasons behind why FIFA started in the first place, that there needs to be a governing body in place to help protect the sport and its competition. This ongoing debate of applying competition law to regulators in sports is a complicated one, where FIFA argues that they must be able to coordinate the international match calendar and maintain competitive balance. Others argue that they do not establish proportionality in the enforcement of their rules, nor do they provide clear or objective criteria for other leagues to follow. In 2023, Relevant Sports LLC brought a lawsuit against FIFA after their sports promotion company attempted to organize some matches in 2018 between teams from two leagues. In response to these matches, FIFA created a brand new rule that same year banning international league games, essentially canceling that match. The Second Circuit revived this antitrust lawsuit, which ruled that the complaint sufficiently alleges that such a policy ban from FIFA that sanctions international league matches violates U.S. federal antitrust law. They ruled that the lower court's dismissal of the suit back in July of 2021 contained a misinterpretation of the 1890 Sherman Act by requiring Relevant Sports to allege that the restriction was implemented as the result of an agreement between the competitors directly. The Second Circuit ended up holding that there was enough evidence to support the lawsuit allegation that the FIFA policy was an illegal agreement made in order to restrict competition. They also noted that courts in New York had jurisdiction over FIFA in the case and satisfied the minimum contacts test due to one of FIFA's agents, the United States Soccer Federation, being in New York while sanctioning the matches. FIFA is not alone in their monopolistic actions imposed upon their competition. The National Football League has engaged in similar actions. The NFL is essentially already a super league composed of the United States' two most dominant football leagues, the American Football League and the National Football League, which combined in 1970 as one super league where the two champions would play each other in a Super Bowl. The two leagues gathered under the name National Football League and composed of two conferences, the AFC and the NFC. This is the way the league is structured today, and since then, there have been virtually no real professional competition to this massive Super League. The United States has seen only two real attempts at competition against the NFL, and even those have been lackluster to say the least. Since the NFL plays mostly in the autumn season, the idea to have a separate, non-competitive spring league was attempted by the XFL, owned by Vince McMahon, founder of WWE. But each of the XFL's attempts lasted a mere one season or less and filed for bankruptcy as the league lacked any real interest. The other is the USFL, who also failed and were forced to merge with the XFL, creating the UFL, which we have today. As the USFL began to dwindle down and lose most of its steam in 1985 after playing only 3 seasons, it decided to make one last survival attempt, a $1.5 billion antitrust lawsuit against the NFL to break its monopoly and potentially even force a merger. This lawsuit that took place in Manhattan's U.S. District Court in the spring of the following year, the USFL's attorney, Harvey Myerson, claimed to have 3 smoking guns, which would each individually prove that the NFL had conspired to monopolize the game of professional football. The first was a memo suggesting that an open network might be an invitation to formation of a new league. The second was a plan to conquer the USFL, which was presented to the NFL management team in 1984 by a professor at Harvard Business School. The third was another legal memo. This one, which pushed that the NFL teams should intimidate USFL teams to increase the salaries of existing players or run the risk of losing them altogether. The NFL merely responded by arguing that the USFL was its own worst enemy and could only blame themselves for the financial woes they ensued. In July of 1986, it was revealed that the jury of 6 agreed with the arguments made by both parties in part. While they did find the NFL guilty of acting as a monopoly, they also determined that the USFL had done itself the most damage of all, creating their own demise with a poor business strategy. Ultimately, the response was to award the USFL only $1 in nominal damages, essentially a symbolic award. Due to antitrust laws, the award was automatically tripled, and after interest became what is famously known as the $3.76 antitrust lawsuit. NFL was found guilty of violating antitrust laws, but this is all that they owed the USFL. The second type of major monopoly system is the internal structure. This type of structure is prominent in the U.S. major sports leagues. Take the MLS, for example. The MLS is comprised of 30 clubs. These teams are set and unchanging. To receive such entry to the MLS, their owners and cities had to pay substantial amounts of money and abide by specific stadium specifications just to receive access to the league. This model feeds off of major big city markets and disallowance of internal competition. This model creates huge geographic gaps in the United States where certain people find themselves cheering for teams hundreds of miles away in entirely different states just because that is their most local team. It also suppresses internal competition. No matter how bad one of the teams performs, they could be number 30 every season and still be in the league the following year because they've paid their dues. This American system is being forced on the non-American game of soccer, and it's not working. This model, on the other hand, looks entirely different in Great Britain and consequently receives much more positive results. The EPL follows a promotional relegation structure where teams risk being delegated if they lack on-field success, but they could also be promoted no matter how small the club or host city if they are consistently winning their matches. The EPL is not a closed league. If it has lower leagues under them that act as tiers, and teams move throughout these tiers seasonally based on their yearly results. If you are not being managed well and are losing the majority of your matches, your team could end up losing its place in the EPL and fall down a league below. This type of system not only keeps the games competitive, as management always has to be on edge, but also dismantles internal monopolies and allows other teams an opportunity to compete in an open dialogue that is constantly evolving. It is hypothetically possible to create a soccer team in England with your friends, and if you win enough, play all the way up into the Premier League. That is the way the game is supposed to work, as it allows anyone to compete and acts as a free market for any team to have a chance at being the best. In the United States, the minor leagues and college sports offer a great variety of opportunity for individual players, but wholly rejects the free movement and allowance of successful teams to compete. They serve different purposes altogether in the U.S. The minor league teams are owned by major league teams and focus solely on developing players for the majors. The minor league teams are not able to work their way up through the tiers to make it to the MLB, no matter how strong their chemistry is or how successful their performance has been. A successful minor league team can never replace a struggling major league team, no matter how bad they are doing. And that is a shame, because it creates unturnable wheels, teams that are run by owners who are just not successfully running their program and continue to lose due to bad management with no repercussions, as they continue to be able to feed off of the advantages of being in the major leagues. Now, I'll admit, the current American closed system, it's not the biggest concern in sports, but it does create this string of issues that results from acting monopolies that shut out other teams who could potentially find success in their league. Right now, the advantage of having a major professional team in your city is a rare commodity, allowed to only 56 cities in the United States and Canada. It is an opportunity to boost city pride, grow local infrastructure, popularize the city, and increase business interest. Imagine if any small city or town in the United States could fight for this same privilege. It could potentially resurrect struggling small towns and give hope to the local community. Dreams and opportunities are what sports are made of, and why they are so important to the tethering of the human race. A merit-based system where any team from any city, no matter the population or amount of money, could climb to the top of the sports world through sustained success and promotion would revitalize the American dream altogether. Let's move on now to the third type of major monopoly system, consumer health, or fan value. Sports monopolies don't just harm their external competitors and their internal competition, but they also hurt their very own consumers. Let's start with money. Specifically the price to enter the arena to watch a sporting event. In this upcoming FIFA World Cup, we have seen many matches rise above 70% in increased ticket prices compared to 4 years ago in Qatar. To give an idea, currently the first match of South Africa versus Mexico is starting at over $2,000 for just one of the cheapest tickets, while the final match in East Rutherford, New Jersey is going for over $8,000 for the cheapest offered ticket after resale value. Adding in the cost to travel to North America to watch your country compete, it seems that the average fans are being priced out of the game they love. These market prices and resale value tickets are not just simply high because there is so much hype and attention surrounding the World Cup. Modern stadiums are doing this intentionally. In New Orleans, the 73,000-seat Caesars Superdome illustrates this example perfectly.
Originally, it was all about being in the stadium and watching the game. Over the years, it's become more and more about fan amenities.
Those amenities are changing the way we move through stadiums and pay for live events. In 1991, it cost around $145 for a family of 4 to go to an NFL game. Today, it's more than $600. The latest Superdome renovation tripled the amount of space for club lounges, carving out more real estate to turn a profit. A redesign of the concession stands around the stadium led to a 23% rise in revenue.
Wow. Stadiums are replacing models that fit as many people as possible with models that create the most revenue possible. They phase out lower class fans with stadium renovations that decrease the number of seats while increasing the value. Since these stadiums host the teams in monopolized leagues, the demand is still high, and people will either be stuck paying more money or just going to less games. This intentional pricing out of fans to only upper-class fans and large corporations monopolize their fan base by determining who can even access the games. When a sports league becomes a monopoly and lacks competition, this creates a lot of issues in relation to game quality. When more games, more cities, and more teams are added each season for the sole purpose of accumulating as much money as possible, it can be easy to see why the quality of the games water down so quickly. When the athletes are playing more games in a season, they are more likely to get injured. In the NBA, they create a secondary in-season tournament similar to the playoffs, but with lower stakes. This brand new tournament, called the NBA Cup, awards the players extra money if they can win a mid-season tournament. The playoffs are fun because they happen once a season, but now if they're twice a season, they may not feel as special. In addition, adding regular season games further decreases the value of each one when it comes to qualifying for a playoff position. And by the way, those playoff positions have expanded as well. This means that instead of just the top 8 NBA teams getting into the playoffs from each conference, it starts with 10 teams, allowing for 2/3 of the entire league to be granted access to the playoffs. If everyone is allowed in, it makes making the playoffs less of a big deal and consequently the regular season less important. This has an effect on players who understand this better than anyone and can be less likely to stand in front of a shot or rebound an important basket when in reality that play risking their injury is worth far less than it used to. Overall, this poor output of lower quality effort affects the league as a whole. The most popular league in the world by viewership is the English Premier League. To understand why, one must look at the model of how the season is formatted. Although there are other leagues and tournaments that clubs compete in, there is no set playoffs or postseason for the Premier League. This creates even higher stakes in the regular season because there can be no playoff run. It's truly a measure of the most consistent team. This format heightens each each match, making each a big deal no matter the opponent, making for an environment where each and every match feels like the playoffs. When compared to the American sports leagues, we see a vast difference where each league is gradually expanding their playoffs, allowing more teams entrance, play-in games, and an increased regular season. This decreases the overall value of each individual game, creating the adverse environment where players don't try as hard but get injured more. Fans can't keep up with all the games and changes to the playoff format, and overall simply makes the games less meaningful. When it first began, the World Cup hosted 13 teams, and since then continued to slowly grow. Since 1998, the system allowed for a total of 32 teams to participate in the World Cup. And now, as popularity grows, the World Cup has decided it is time to finally expand once again. This upcoming tournament will host 48 countries, creating 4 more tables in the table stage. The knockout stage rules have changed as well, allowing for the top 2 countries of each table to be invited along with the next 8 highest rated teams, which means that now that knockout stage will feature 16 additional teams and an extra round entirely. This new round of 32 means that each team will have to play an additional match in order to proceed to the usual round of 16 where the bracket had normally begun in years past. In total, the tournament had expanded dramatically from a total of 64 games all the way up to 104. So now that we've examined these monopoly structures, let's take a look at the effects they are having. And let's start with travel. There's more travel this year in the World Cup than ever before. In some cases, teams will be traveling the entire width of the North American continent in between games after they've already crossed the globe to arrive here. Teams understand this and are strategically already planning on setting up camps in areas around the continent to give them travel advantages. These camps range from places near their first match to locations in the middle of the table matches, while some are simply choosing locations near the geographic center to have an equal distance no matter where their games are. In order to keep up, teams are now realizing that the tournament is not simply a contest of the best soccer team, but maybe which team has the best logistics manager. This increased travel will surely be a high demand on the athletes and their on-field performance, and the table match scheduling has not made it any easier. There is a radical disparity in travel distances between teams. Take a look at this graph. France, for example, has little travel from Boston to Philadelphia, where they will only be traveling a total of 334 miles for the table matches. Argentina is in a similar advantageous position, where their 461 miles between Kansas City and Dallas offers little difficulty. But there are drastic differences. England also plays a match in Dallas, but then afterwards has to travel all the way up to Boston for another match, totaling over 1,700 miles. The hosts have by no means any advantages either. The United States will travel the entire height of their country as they fly from Los Angeles to Seattle. Canada perhaps is in the worst position of all, as they will be traveling over 100 miles more, traveling 2,084 miles, as they are required to travel the entire width of the continent and have coast-to-coast matches in both Toronto and Vancouver. I'm sure you've already seen many of the effects these monopolies have created. I encourage you to continue researching the increase of player injuries, the lack of accountability for FIFA's human rights violations last tournament in Qatar, the inflated gambling issues both inside the league and by fans, and athletes' mental health, just to name a few. When the quality of the games dip, this begins to affect everything. And with no accountability, lawmakers seem to continue to look away. Things are getting bad. It's estimated that thousands of migrant workers died in Qatar's preparations for the 2022 World Cup. Statistics show that 4 years after a state legalizes online sports betting, household bankruptcy rates increase by 25 to 30%. League players and coaches are being investigated by the FBI for internal gambling schemes, and athletes are feeling increased emotional strain from the stress of bettors berating them when they lose. Sports are the very fabric that make up humanity. It features man's love for competition, athletic rigor, and people from all walks of life coming together to participate in a team sport. Individuals who lose a little bit of themselves in order to sacrifice for the whole. Sports feel like they're a part of us because they've always been with us. They are hard to let go. That's why the solution is likely not a simple boycott. Sports bring out the best in us and help cities, businesses, and private citizens in countless ways. As members of the legal field, you have been given a unique position to make change for the better. Sports monopolies don't fall from within. They get slowly torn down by courts and regulators through enough legal pressure. They also fear monetary pressure, as these leagues thrive and survive off of fan spending and corporate sponsorship deals. You have the power to slowly chip holes in the aspects to slowly move the needle. In 1890, Senator Sherman stated that if we will not endure a king as a political power, we should not endure a king over the production, transportation, and sale of any of the necessaries of life. When there is a challenging task that requires dedication and heaps of creativity, the outcome is worth it. It can better society, it can better each other, and it can better sport. Thank you so much for listening. God bless and enjoy the rest of the symposium.
I'm sorry? Yes, they did. That's why when I received the video from James and I started watching it, I was like, I reached out to him and I was like, I didn't know it was going to be a whole production. I expected, the Zoom recording of one, But so no, I think that was an excellent way to kind of wrap up the all of our to wrap up this symposium. Let's see. There we go. So okay. I'm gonna put this putting that up temporarily. So we've made it through the 2-day symposium. We've had some excellent presentations. And first of all, let me again thank the closing panel for the very thoughtful, very engaging presentations. Thank you all very much. You have, like I said, this is a great way to, a great note to kind of wrap up the symposium. Let's see. Oh, and I put that up also so that you guys know, in case you didn't get the QR code at the front, you have it here. It takes you to the website, and we will keep updating information on the website, and this will become even more relevant in a moment. So now my other little surprise for you. Okay, part of this symposium was a call for papers, right? And the call for papers, we had, I think we had 13 abstracts that were sent, 9 papers that were submitted. So before I announce the outcome of that, let me give you a little bit of background on the Houston Journal of International Law and the whole process that they engage. So the journal publishes 3 issues per year with 3 articles per issue. And I should also first mention that Hijal wanted to be here. We thought we were going to have a representative here, but they weren't able to make it. So they helped me with some comments to provide to you. So 3 issues per year, 3 articles per issue. For the first issue, 2 articles had already been pre-selected from previous submissions, leaving room for 1 additional submission for the upcoming issue. The editorial board intentionally limited the selection to 1 paper this cycle because the current board will soon graduate and the incoming board is slightly smaller. Let me explain this for anyone not from the US used to journals that are associated with law schools. So the journals are typically primarily run by like the top law students. of that particular law school. And so they make up the editors, editorial board, all of that. And so, the current one, since we're in March, they're looking forward to graduating in short order. So, and then the other one will be seated in the new academic year. Let's see. So, yes, so the incoming board is slightly smaller. This approach allows the new board to assess their editing capacity before committing to additional articles. So the selected article, so one article from the submissions will be selected. So the selected article will appear in issue 1 in the fall of 2026. The editing process, just in case you're curious, the editing process will begin around August or September 2026 and typically takes 60 to 90 days, including time for the author to review and respond to editorial suggestions. Once editing is complete, the article will be sent to the publisher. For our authors, and this is important, for authors who were not selected this time, submissions for issues 2 and 3 will reopen in late May. At that point, the new editorial board will review submissions and make their selections. Let me also note that, that they were very impressed by the papers that were submitted. They were really impressed at the high quality, and they really strongly encouraged that if your paper was not selected, that you please consider resubmitting. And the information for resubmitting, and that's why I put the QR code up. You can follow the QR code under program. There's, it says HIGIL, and then, I'm sorry, not HIGIL, it says abstract submissions. At the end of that document is how you can submit through Scholastica or directly via email to higil.submissions@gmail.com. So, without further ado, I am going to let you know the article that was selected. So the article that was selected was an article submitted by Helene Sedone and Isabel Lopez Padilla, Labor Rights Risks in Supply Chains in Mexico ahead of the 2026 Men's FIFA World Cup and leveraging the USMCA's protection framework. So, yes, and also just a note, Helene and Isabel had every intention of being here, and I should also say, I didn't even find out the selection until the day before this conference. So Thursday is when I found out. And so, unfortunately, just last week, they had to pull out of the conference, but they had intended to be here. So yes, but again, their paper was selected for that one spot. And also the other thing is in sending out the call for papers, I did not, I left all of that to HIGIL. And so I had no idea how many papers would be selected. They couldn't tell me up front. They didn't know. So yes, but please consider
What is their
resubmitting.
affiliation? Are they scholar professionals?
I'm sorry. Yes, oh goodness. Oh, you know what? They're I put their abstract. Trying to think, did I include their bios? I know they're both practicing attorneys. I think Helene is in public policy, and then Isabel is with the private firm, if I'm not mistaken. I'll try to make sure that information is available as well. Thank you. I didn't think about that. So that's it. Okay. So then I am going to properly close this symposium. So, as we conclude the symposium, I'd like to take a moment just to reflect on what we've explored over the past 2 days. We have seen how the 2026 FIFA World Cup is far from more than just a sporting event. It is a regional governance experiment, a test of cross-border coordination and a lens through which we can examine the intersections of law, trade, labor, ethics, human rights, and technology. Several themes emerge from the discussions. First, cooperation across borders is possible, but it requires structure and accountability. The United States, Mexico, and Canada must navigate complex legal, labor, and infrastructure frameworks to make this event succeed. Second, human rights and ethics cannot remain symbolic. Enforceable oversight, independent monitoring, and operational accountability are essential to protecting workers, fans, and communities. Third, technology and infrastructure are not neutral. They shape how the World Cup is experienced, who benefits from it, and how risks are managed. From cybersecurity and media influence to procurement decisions. The challenge for all of us, scholars, practitioners, policymakers, and students, is to turn knowledge into action, whether through research, advocacy, or collaboration. We can help build governance models that make mega events safer, more transparent, and more accountable. So, thank you to all of our speakers, moderators, sponsors, Greenberg Traurig, Stratia, and the Houston Journal of International Law, and all of the attendees for making this symposium such a rich and meaningful exchange. I also have a very, very, very special thank you to the Symposium Planning Committee, and especially to those who were able to join us here, and a very special one to the co-chair of the symposium, Julian Cardenas. And then also another planning committee member, Brian. Thank you, Brian Michael Cooper. Matt Mitten, who had to leave, but yes, and I think that was all of us, right? Oh, and Zahan, who was also on the planning committee, one of our student representatives. And you can see the list of all of the planning committee members on the website and in the program. So I hope the ideas generated here continue to shape conversations about the governance of the 2026 World Cup and global sport more broadly. But equally important, I hope that your sports law community has been expanded through the individuals, the people that you've met during this symposium. So thank you all again, safe travels, and enjoy the beautiful Houston weather.